I filed a criminal petition, my lord, on 19th, my lord. So I beg before lords to be listed on Friday, lords.
Actually, there's a senior bench is dealing with this thing. So you have to make a mention before the court number 21.
But I have
Mention before court number 21.
But I have seen the the cause list and this roster. The motion matter only allotted to your lordship's court.
No. Yes, that's it. But the question is that if you make a mention before the court number 21, it will be listed. This is senior bench, that's why.
Yeah, please, Your Lordship. One officer that was rejected to your lordship in India also. And the letter was fixed on 6/11. It was earlier rejected by your lordship. And subsequent bail application was fixed on 6/11. That day your lordship was not available, so letter could not be taken away. And yesterday lordship, this letter was listed on the state of mention book. But your lordship could not be taken up. Yet your lordship will be taken up on tomorrow lordship. Because 90 days already over lordship.
Tomorrow, I mean, just he is saying that 90 days, that's why I'm taking. Otherwise, maybe it's set on Friday or Monday. Monday is also Friday.
He is in jail, my lord.
Everyone is in jail.
On Friday.
May it please your lordship, I beg to mention item number 7.
07.
07. Senior counsel is not doing well. Kindly be adjourned for the day and maybe fix next week, lordship.
Next week, 1 week after 1 week, it will be listed.
Yes, next week, lordship.
Senior counsel, Mr. A21, it's A.M. Bora.
Lordship, I have one more prayer. Item number 38.
Item number 38.
38. This also may be kindly adjourned for the day and be listed next week. It's AB matter, lordship.
No. Item number 38.
Yes, lordship.
30 is an AB matter.
Criminal
It's a criminal
petition.
petition.
So, sorry, lordship.
Criminal petition only?
Yes, lordship. Devangana.
But here, name of Mr. A. Bora is not reflected.
Only DK Boyddo is reflected. I guess.
Boyddo's name is also not there.
Okay.
Maybe.
Lordship, I will take the.
Yes. Take it.
May it please your lordship, I beg to mention for listing for Friday lordship. Bail application. Friday lordship. Friday lordship.
Friday, lots of matters are already been fixed. You see. Monday.
Monday.
May it please the lordship. Lordship, I beg to mention item number 18 of today's cause list, my lord.
18.
18. Can it be taken up on Monday, my lord? Bail hearing matter, my lord. LCR is also there, my lord.
Naturally, it's a NDPS matter.
Yes, my lord. It was earlier heard and decided by your lordship, my lord. And rejected, so that is the lordship. On Monday, my lord, please.
27. Listing it on 27. Not Monday.
26, my lord, if possible. 26. Please, my lord.
There may be some other programs also, yes, because 27, it
My
has been 27.
lord. And another small prayer with regard to item number 28 and 30, my lord, of today's cause list. There, my lord, I have been told
28 and
30, my lord, 30. Yes, there I have been.
AB.
Yes, my lord, AB, my lord, and perhaps case diary was not received, my lord, in these both cases. And both the petitioners are with interim, my lord.
You have received here? Not received. In both the matters, 28 and 30? In both the matters, you are on interim?
Yes, my lord. Yeah.
Interim be extended, issue reminder. Yes, when it can be listed? 5/12.
5/12. 5/12, my lord. Obliged, lord.
Yes. Yes.
May it please your lordship. My lord, I'm still trying to catch up with my breaths, my lord. In fact, item 49, I have filed an additional affidavit. So your lordship may be pleased to call for that. Apart from there, my lord, I am also making a prayer, my lord, for upgradation of item 49 to be taken up at 2 p.m. on the count, my lord, that some consideration by your lordship is necessary because the trial court's order is going to seriously prejudice me, my lord, in absence of any interim order passed by your lordship, my lord. So lordship will take up at 2 p.m. item 49. Obliged, my lord.
May it please your lordship. One criminal appeal 324 of 2023 was listed yesterday, but because of my lordship unavailability, it could not be taken up yesterday. So on the request of the senior counsel, may it be listed on the 29th of this month, 29th, Friday.
That matter was
On 29th, my lord. Yes, Friday.
not the hearing day.
And should we list it on 28th, and if not possible on 28th, we'll get it listed on 29th, my lord.
Otherwise, 28.
Yes.
28 will be okay for you?
Somehow.
Somehow?
Yes.
Okay, then 28.
My lord.
Fixing it on 28?
All right, my lord. Much obliged, my lord.
May I please the lordship I beg to mention item number 58 and 59.
50?
8 and 59. Lordship,
Yes.
Lordship 59, Lordship.
Only 59, my lord. With respect to 59, she is making a mention because, my lord, I am the petitioner. In 59, my lord, he is a cancer patient and a report from the Biburua Cancer Hospital has been called for. But, my lord, we have checked the record. The report from Biburua Cancer Hospital has not come.
You are praying for 58 and 59, both.
Lordship 59. 58, Lordship 59, Lordship.
59.
only.
Though
They
it
are
has
all
come,
connected matter. But it is a connected matter.
my lord, it has to be, my lord, disconnected because, my lord, 59 has got nothing to do with 58. 59, I am appearing solely on the ground of cancer patient, blood cancer. 58, let it come on the when the item is called for, they will make the concerned advocate will come, my lord. As far as 59 is concerned, that may not be fixed with 58, my lord. Even last occasion also, it did not come as a tag matter. I don't know why it has come today.
Out of same, I think.
Same FIR, but
then that's why it has come.
Absolutely grounds are different, my lord. We are not at all because 58, in fact, the earlier set of advocates have withdrawn their wakalatnama. No new set of advocate has been appointed.
But your name has been reflected there also.
My name, my lord, I don't know. My name is in 59.
Your name is in 58 also.
58, I don't know, my lord, how it has come. It is
Lordship,
59.
let the matter
Reach.
58, Lordship.
59 maybe adjourned. 58, let the matter be reached. If required, I'll also be there.
59 to adjourn. 59 when you need.
Lordship, any day, Lordship. Lordship,
A report
was
as
called
per
for-
your information report is not
As per the record, my lord, I have checked the record.
yet received.
It is not received. The report from Biburua Cancer Hospital.
এডমান লিখিব নালাগে এডজন কৰি দিওঁ আদাৰৱাইজ কেতিয়া দিব Tuesday, Wednesday, Thursday, any date.
Lordship, report was called from Central Jail Authority.
A reminder may be
Direct
sent.
reminder.
At a 50.
এইটো হাৰ্ড কৰি দিয়ক ডিপ্লেকক it is submitted by learned counsel Mr. Biswas for the petitioner that from the records it is seen that the report from the Biburua Cancer Institute is not yet received. Full stop. This will
My lord, we see the last order.
this one the registry. Accordingly, registry is ever directed to send issue reminder to the hospital authority to send the report as sought for. List accordingly. Full type it, please.
Last order to ever last order to ever This is the last order. Last order to ever.
It is in 58. What is your name of your petitioner? Who is a cancer patient?
Haricharan Biswas.
Then you're confusing code only. There is no Haricharan Biswas.
Yes, my lord, there is Haricharan.
59, there is no Haricharan Biswas.
I'm sorry, my lord, it is 58 Haricharan Biswas. I'm sorry.
এটা করে দিব এটা। JFG report is to receive from the jail authority. Report is to receive from the jail authority.
From Bigurua Cancer
Then
Hospital.
again you are submitting wrong submission is there, the wrong case.
Bigurua
listing is
Cancer
there.
Hospital was supposed to send the report to jail authorities, my lord.
Jail authority pan. Jail authority ka kore dibo. Send the report but it is sent to jail authority. After collecting the report from the Bigorua Cancer Institute, if any. Well, it can be listed then. Report is required. And we take my 3rd of December.
My lord, 80 days barring third, my lord, 1 or 2 days.
Huh?
Maybe after 7th of December, any date after 7th of December, because from 3rd I'll not.
After 7th.
After 7th.
After 7th, then 11th. It is 58 or not a 58. Yes. So 59 is pending, huh? 58 we have.
Meet, is your lordship. Lordship, I beg to mention item number 27, your lordship. So anticipated bail application, lordship. May I pray the matter may come up next week, your lordship.
We have received the case there. Any problem?
Lord, there is some difficulty on our part. The senior counsel is not present, lordship. After a week, your lordship. Otherwise, we are on interim, your lordship. 27.
27 liquidable, CD receipt, the request made by the so and so. This matter accordingly. So we have to give a date within after 1 week. Otherwise, we have to retain the case diary. Case diary may be retained.
Then 27, your lordship.
27th?
Lordship.
27th.
Lordship, there's an interim order, lordship, that has to continue, your lordship.
Interim be continued till next date of this.
Lordship.
11. We have taken consent from the P sector, madam. Is the legal counsel. Can be after.
You are for the petition. With the consent of the legal counsel. After 1 week, we do. In the 2019 matter, we are listing it after 1 week.
That's the interim order.
Interim was there. Interim continuing from 2019. Very nice.
Recently, this
Interim be continued.
legal counsel has appeared, madam. Recently, the legal counsel has appeared. This case is we start copy. Another item, I think not.
Microphone is still not working, I think.
Another item, my lord, item number 36 from others column. Same prayer.
Here also you are for the petitioner. Was there any interim? একে order করিব 1 week listing করিব interim be continued
Can be after 2 weeks, madam.
2 weeks
2 weeks.
list after 2 weeks.
May I please, Your Lordship? Lordship, I beg to mention item number 33. Lordship, my senior Mr. S. Chauhan is not well today. Kindly adjourn for the day, Lordship.
Mr. S. Chauhan is not well.
Yes, Lord.
Otherwise, in 38, yes, 33.
33.
Not received. Was there any interim?
No, Lordship.
Interim was not there. Case there not received, issue reminder. In list 312.
Lordship, kindly 512, 312 senior is not.
You want 512?
Obliged, Lordship.
Lordship, I'd like to mention the petition, file number 1061/24. My lord, the petitioner in this case, I'm for the petitioner.
Item number, just tell us item number.
It is not listed yet.
Oh, for listing, you make a mention before court number 21.
May I please, Your Lordship, my prayer is for listing. I, Lordship, started matter is listed before this honorable court, but matter is left over. So,
Again, you make a mention before the court number 21.
May I please, Your Lordship? I beg to mention item number 56 of the supplementary list. In this matter, my lord, yesterday Your Lordship has directed us to file an amended cost item. The same was filed by us, but however, the record was sent from the bench to the section at around 5 p.m. And hence, due to paucity of the time, the same was not accepted. Right? And hence, again today we have filed a new one, and the same may be allowed us to put into the record.
So you have already filed.
We have filed.
Then it may come. We may call for.
Let the matter come up at 2 then final.
Two, I have some matters from VC to from Itanagar bench, in fact. So it will come. We'll see.
May I please, Lordship?
Additional affidavit.
May I please, Lordship?
Amended.
May I please, Lordship? I'd like to mention item number 60 and 61, Lordship, for supplementary list, Lordship. We have requested for VC, Lordship. There is an urgency in the matter, Lordship. Statutory period is about to reach, Lordship.
VC now see at present at this stage I cannot say because for at 2 the another VC is there from Itanagar.
Lordship, let it come in serially, Lordship.
Huh?
Let it come in serially, Lordship.
Since 61.
Yes,
Mr.
Lordship.
A.M. Bara is also appearing in 61.
Yes, Lordship.
So in other matters, so you have taken adjournment.
But there is an urgency in this matter,
Why?
Lordship.
What are urgency?
Lordship, statutory period is about to reach, Lordship. Today is 77 days, Lordship.
CBI is there, no? CBI informed police. Have you informed CBI? Standing Council CBI, have you informed?
Lordship, we have the matter today, Lordship.
I cannot exactly say. Let the matter be reached. I shall see.
Lordship.
Item number 35 is a POCSO matter. So we have taken steps for service of notice on the respondent number 2. The Lord PP was directed to obtain instruction as to whether service was completed or not. There is no office nor otherwise showing service matter. Office of Naik.
Matter may reach. Then
Let the matter reach.
Item number 25, my lord.
25?
It is not reached.
Yes.
Interim is there, my lord.
CD is received? Not received. Your interim is there. Interim be continued. CD not received. Issue reminder. Yes. Sami when?
6/12.
May please, Lordship.
So there was one judgment to be pronounced. Probably it will be pronounced at 2.
At 2.
One of my colleagues would be there.
Okay, sure.
For motion item 1.
May I please, Your Lordship?
Yes.
483 application, Your Lordship. The petitioner is behind the above 44 days, Your Lordship. The POCSO is there, Your Lordship. Lordship, I have, and the one praise, Your Lordship, the petitioner is 19 years college-going boy, Your Lordship. A short day may be fixed, Your Lordship. That is my prayer, Your Lordship.
Yes, Kusami, when it can be fixed. From where it has to come?
Kamrup factory, Your Lordship.
to বেশি early হবো 29 of 11
29/11 city. Oh, it's a POCSO. Oh, notice. They are. It's a POCSO. They take steps for issuing notice. Okay, issue notice to respond. Item 2. Process to DD go through registry.
notice to them call for a record in the meantime.
It's a POCSO. Issue notice. We are also calling for the case diary.
Not totally. Search the case. Scan copy
Oh,
of
is
the
this charged one? Okay. Issue notice to Mangdyok and the scan copy of the case diary we call. What is the stage of the case at present?
4 witnesses already examined.
4 witnesses.
Scan copy
Okay.
of
Lower court record.
Okay.
And this is the registered post. Notice. Through registry.
Not through OC, or through OC, through the office of the registry and public prosecutor. Routed through the office.
Date, maybe.
Yes, Kusami date. 5/2.
Item 3.
May I please, Your Lordship? Unless we have in this matter, Your Lordship, respondent number 2 is represented by the learned counsel engaged.
Yeah, well.
Your Lordship, here in this matter, the petitioner is behind the bar since last 42 days, Your Lordship. And petitioner is the father of the accused number 1, Your Lordship. FIR charge sheet is matter, Your Lordship, and FIR is at page 18, Your Lordship. May I read the FIR, Your Lordship? Page 18 is the translated copy, Your Lordship.
Lordship, page 18 is the FIR, Lordship. May I read the FIR, Lordship, small one, Lordship. And this petition is for the Lordship, father-in-law of the alleged victim, Lordship, not for the husband of the alleged victim. Page number 18, Lordship. Humble submission is that the officer in charge of so-and-so police station through email informed the officer in charge of Agomani police station about the commission of teenage pregnancy of one minor girl aged about 17 years of so-and-so. After conducting search with regard to the said incident, I came to know that the name of the minor girl is Amina Khatun, aged about 17 years 6 months, daughter of so-and-so police station so-and-so. And about 2 years ago, having love affairs with one Alamgir, took her away and got married at his house and had been continuing their conjugal life. 6 months back from today, said minor girl had given birth to a boy child at SD Hospital, Tufanganj. Presently, she is living at so-and-so along with her family. It is learned that the marriage was solemnized at the initiation of both the families of the boy and girl. Lordship, if anything against me, Lordship, is this line, Lordship. It is learned that the marriage was solemnized at the initiation of both the families. I am the father of the boy, Lordship. Now, Lordship, in this case, charge sheet has been submitted. Lordship, may kindly come to page number 31 for a moment, Lordship. This is a case of child marriage, Lordship. 31. It starts from 30. Page number 30, Lordship. Last paragraph I am reading, Lordship. During investigation, place of occurrence was visited, the informant witness and the victim was interrogated, the victim was medically examined, the birth certificate of the victim was seized and placed before the Honorable Court. The register copy of so-and-so sub-center regarding the victim's son has also been seized, and from that it is learned that it is around 2 years ago, the accused Alamgir and victim Omina Khatun, aged about 17 years 6 months, fled away from their respective residence and thereafter their marriage was solemnized secretly under the guidance of accused Kasirali. This is me, Lordship. And out of the said wedlock, victim has given birth a male child, Arman Ali, who is presently 4 months old. During investigation, a case under Section 9 of PCM Act, read with Section 6 of POCSO Act, against the Alamgir, that is number 1, and a case under Section 10(11) of PCM Act, read with Section 17 of POCSO Act, read with Section 77 JJ Act against Kasir Ali, so and so, that is me, Lordship, have been established, and as such, both the accused persons were arrested and forwarded to judicial custody. My humble submission is that, Lordship, this is a case of child marriage, and I am the father of the accused number 1, Lordship. My name is not there, Lordship, in the FIR also. It is admitted, Lordship, that even, Lordship, in the charge sheet, it is clearly mentioned that both the alleged victim and the petition and the son of the petitioner were in love, and they fled away from their house. Lordship, I am the father, Lordship. Since last 42 days, Lordship, I am in custody, Lordship. Therefore, Lordship, my humble submission is that Lordship may kindly consider my bail and enlarge me on bail. My learned friend is appearing for the informant, Lordship. My learned friend is appearing for the informant.
He will support you, I know.
Yes, Lord.
What is it?
POCSO 6 is there, Lordship?
POCSO 6 not against me, Lordship. In the charge sheet, it is not against me.
It is a suspected case. You have to go through a record of it. But this after going through a record of it, Lordship.
Yes.
Please, my lord, marriage was solemnized secretly without the knowledge of the my lord guardian, my lord. So, my lord, the involvement of the guardian, as I understand and obtain information, my lord. So, my lord, this was a love marriage, and they performed the marriage without the knowledge of the guardian, my lord. So now they are living, my lord, peacefully. And they
No, you are for the informant.
Yes,
No,
Lord.
my lord.
Mother of the victim.
Yeah, that's what I'm asking. You are for the informant.
No,
Informant is third party.
Third party, my lord. Not the mother lost this informant. I'm the mother of the victim, my lord.
Mother of the victim is a party here.
Yes, Lordship. I have made mother of the victim as a party, Lordship. As per the Deepak Nayak judgment, Lordship, it is necessary that victim's family should be made as a party, Lordship. Respondent number 2.
That means you are also an accused.
No.
No, my lord.
No, you have given consent of child marriage.
No, I have not given consent. my lord.
Who gave
Marriage
consent?
was-
And you are
marriage was-
saying that
No,
yes.
marriage was solemnized, my lord, secretly, my lord, without our knowledge, my lord.
Without your knowledge, with the mother of the victim.
Yes,
And what about the other?
my lord, as per my lord, as per my knowledge, my lord, obtain, in this meantime, I could learn that my lord, that they did not obtain permission from their father, my lord. So it's a petitioner, my lord.
That is also obtained, instruction is also obtained by you.
My lord,
When?
Even
since my lord, they are, my lord, it is almost, my lord, around more than 1 year, my lord. So, my lord, in the meantime, they decided so I could obtain information from the my lord victim girl that they, my lord,
You could not?
I obtained information from the my lord victim girl. My lord. My lord, the solemnized marriage, my lord, without the knowledge of the my lord, the father of the my lord.
Even, Lordship, if you kindly allow me, Lordship.
So you are the informant and you are supporting this thing.
I'm not informant, my lord. I'm the mother, my lord. Informant is a third party, stranger, my lord. Not the family member.
Yes, he is doing his duty. Supporting.
No, my lord,
Supporting.
I'm not supporting, my lord, but
No, supporting the accused.
No, my lord.
No, you are supporting. Yeah, I will record your submission only now. Hard Mr.
If Lordship kindly allow me just to make one submission, Lordship.
Hard Mr. You are Mr. M. Ahmed. No?
Yeah, ma'am.
Hard Mr. M. Ahmed, the counsel for the petitioner. And also hard Mr. D.P. Goswami, the learned additional PP, appearing on behalf of state respondent. And you are Mr. M. Islam, the counsel appearing on behalf of the respondent number 2, comma, / the mother of the victim. It is submitted. This is an application by Likiba. It is submitted by Mr. Ahmed that the present accused petitioner is in custody since last 42 days. And considering his period of detention, also he may be enlarged on bail. Further, he submitted that the case has already been charge sheeted, and the present accused petitioner was not an FIR named accused. However, the police filed the charge sheet against the present accused petitioner, incriminating him in the said offence. Most. He further submitted that both the accused number one, that is his son, and the victim had love affairs, which is also reflected in the charge sheet. And out of the love affairs, they fled away and got married. But the present accused petitioner had no knowledge about the same. But at present, they are living happily, and the victim has also gave birth to a child. The present accused petitioner will appear regularly before the court as and when the date fixed, and there is no, and being a permanent resident of his address locality, there is no chance of absconding. Next problem, Mr. Goswami, the learned additional PP, submitted in this report that the case is registered under section 9, 10, 11 of Prohibition of Child Marriage Act 2006, read with section 6/17 of the POCSO Act, and hence is submitted that the scanned copy of the case record may be called for before passing any order on bail. Next paragraph, Mr. Islam, the counsel for the respondent number 2 / the mother of the victim, submitted that the present accused petitioner had no knowledge about the marriage of the victim and the accused number 1, and it was not within their knowledge, within his knowledge. However, presently the victim is residing happily, and she also gave birth. She also gave birth to a child. Mr. Islam further submitted that he has no objection if the accused petitioner is allowed to go on bail. Next part, considering the entire facts and circumstances of this case, materials available in the case record, that is the statement made in the FIR as well as in the charge sheet, I find that further custodial detention is not necessary in this case, and accordingly this court is of opinion that this is a fit case wherein the accused petitioner may be granted bail affordable. Where it is pending, case is pending.
My lord, special judge Thupri, lord.
Special judge
Thupri.
To the satisfaction of special judge Thupri. Okay, you are allowed to.
Highly applies.
May it please your lordship, my lord. A very small, very tiny issue before your lordship, my lord. Whether the order of maintenance under section 125 CRPC shall be passed with effect from the date of the order or from the date of filing. This is the issue, my lord. I am the wife in the family court in the matter under section 125, and the order of, we filed the petition on 20 April 2020, and the order of interim maintenance was passed, unfortunately, only on 13 August 2024. That too giving effect from the date of the passing of the order. Challenging that, we are before your lordship. There are Supreme Court judgments. It says that it should be from the date of filing the application. I have quoted a portion of the judgment in the petition itself.
But that's one thing we say. This delay is due to fault of the respondent, or
they are mixed because of COVID, because of mismanagement of the case also. I am not on that. I am on the fact, I am on the point that whether it should be passed giving effect from the date of filing or from the date of order. Supreme Court says that it should be from the date of filing. Lordship may issue notice.
Only one respondent, I think.
Only one response.
Third, Mr. Yesuma, the learned counsel for the petition. Again, this is an application so and so. Challenge to say order. The judgment has already been passed or
It's
interim.
an interim order.
13/8/2024 is the interim order.
Interim order. 4 years later.
Interim order against the interim order dated 13/8/2024 passed by the learned principal judge, family court number 2, Kamrup M at Guwahati.
It's Kamrup L, not Kamrup M.
Kamrup M.
No, M is not there. It's for both
you're
the
mentioning
Kamrup.
M, that's why I thought.
Oh, actually, it should not be M.
But in Kamrup, is there any whether there is 2 family courts in Kamrup?
No, that is
idea.
why. There are no 2 family courts.
Yes, only one.
Only one. Here it is wrongly written
One
as
is
M.
also not there. One is there. His family court is there in Kamrup.
No, that is why I know, so far my knowledge goes, Milord, it is Kamrup, not Kamrup Metro. Anyway, if they are written as Kamrup Metro, I can't help.
No, I'm not on that. In Kamrup Rural, Kamrup Rural, I don't think there is any family court.
Yes, correct.
That's why it is Kamrup M is correct. In Kamrup M, there are 3 family court judges, principal judges. But in Kamrup, there is no principal judge. I think so.
Previously, it was written Kamrup. It's all right. It's Kamrup Metro.
Now
there.
to Kamrup M only.
Okay.
Kamrup M. Issue notice corridor. Also call for the scan copy of DLC. We're listing it after 4 weeks.
Let me fix a date. So far as question of maintenance is concerned.
Any date after 4 weeks, any date. It will be on 16/12.
Well, I'm obliged.
Lordship, kindly pass over for time being.
Item 6.
The state is also party.
Yes, sir. Comment. Yes. Done.
None appears on call for the petition. Heard Mr. MP to sign the learned additional person appearing for the state respondent. List the matter accordingly after 1.
Item 8.
May I please, Lordship? Lordship, in this case, I am just challenging the impugn order dated 3/6/2023, whereby the learned court below had taken the cognizance against the accused person under Section 138 of the Negotiable Instrument Act. And the Lordship, in this case, I am not a drawer of the check, Lordship. Lordship, the check was not drawn on my bank. And the Lordship, the check was issued by my wife, Lolita Boro. And the Lordship, since I have not issued the check, so Lordship, there is no offense under Section 138. And the Lordship,
Is there any joint account, joint liability? Was there any?
The Lordship, I have
Which
no
wife,
any
your
choice. Lordship, there is no joint liability. But Lordship, in this case, I entered into an agreement with the father of the complainant for sale of the land, Lordship. And the Lordship, that agreement, thereafter, Lordship, I could
Your
not
wife is also
no, Lordship. She was not a party of that agreement, Lordship.
No, she was not a party.
Yes, Lordship. Lordship, kindly peruse, Lordship, Annexer 2, Lordship, agreement for sale.
At page number?
Page number 85, Lordship. And the Lordship, the check was obtained from my wife by the complainant. And the Lordship, she has no any liabilities. And the Lordship, I did not issue the check. And the Lordship, in this regard, Lordship, I want to submit a judgment, Lordship.
No, whatever, we'll see to it. But the question is that you entered into an agreement on the basis
Yes.
on the in person to
Yes.
that agreement.
Yes,
the
Lord.
check was issued.
But Lordship, check was issued from my wife.
Obviously, in person
Yes.
to that agreement, only check was issued.
Yes, Lordship.
Most probably that will be the reason.
But Lordship, I am not a drawer of the check, Lordship. I have not
Obviously, you
issued.
are not a-
And there is no offense under Section 138, Lordship. Because Lordship, I want to submit a judgment.
Okay, we should notice at present.
Lordship, kindly stay maybe given Lordship, because Lordship, otherwise the court will prosecute the case against me, and there is no offense under
Where is
section
the order
130.
of cognizance?
Yes, Lordship, page number 103, Lordship, Annex 9. Lordship, cognizance has been taken under section 138. But Lordship, there is no commission of offense under section 138 since I have not issued the SEC. I have no any liabilities, Lordship.
Heard Mr. S. Dewey, the counsel. You're Dewey, na?
Yes, Lordship.
Heard Mr. S. Dewey, the learned counsel for the petition. This is an application under section 528 of the BNSS for quashing and setting aside the impound order dated 3/6/2023 passed by the learned court of A. Bordeaux, the Judicial Magistrate First Class, Kamrup M, in NI case number 3046 of 2022 under section 138 of NI Act, comma, whereby the cognizance has been taken against the present accused petitioner under section 138 of the NI Act. Issue notice to the respondent to register AD and also call for the scan copy of the LC. Next para, heard Mr. Dewey on interim prayer. Post stop. Next para, it is submitted by Mr. Dewey that the present accused petitioner is not the drawer of the check and he has not issued the check in question. However, there was an agreement between the complainant and the present accused petitioner, but he has not issued any check in pursuant to that agreement. Rather, his wife had issued the check, and thus he cannot be made liable under section 138 of the NI Act, wherein the cognizance has already been taken by the learned trial court below. Next part, considering the submission made by so and so, stay corrigible. We further proceeding be stay in respect of the petitioner till next date of listing.
Obliged, Lordship.
After 4 weeks, you take steps.
Yes, Lordship. Obliged.
Item 9.
May I please, Your Lordship? 528 application ready for quashing the entire criminal proceeding.
FIR.
Oh, sorry. Entire criminal proceeding, Lordship.
Criminal proceeding.
Pending before the learned court of judicial magistrate first class, Kamrup. The allegation made in the complaint petition is that the present petitioner submitted income tax return
Yeah,
for the
representing
assessment year.
state is also here. Income tax. That's what.
Because the informant is the complainant is my income tax officer here.
Here we have the special public prosecutor, I think, na, for tax.
Yes, special complainant and also income tax.
Income tax.
Complainant is the yes.
Standing counsel, sir.
Income tax officer.
Standing counsel, sir.
Standing counsel is there.
Yes. The name may be shown.
So in that case, whether they have to make party to the or state can be represented. Otherwise, they made party. State is.
Complaint division. So response number 2 appears.
No, defense. Response number 2 defense is required, but I am saying that if a state respondent is 1.
Lordship, since it was filed by the government employee, therefore state was made party.
Yes, that's why. He's saying that the government employee filed the complaint.
Issue only notice, notice may be issued, but the name of standing counsel is
Otherwise, let the standing counsel for the department.
And after issuing notice, if they appoint any advocate, standing counsel, or they may appoint other counsel.
Then we cannot. Okay, in that case, we are going to issue notice only at present. Otherwise, we don't have any alternative
Lordship,
without hearing the other side.
Lordship, there are certain apparent
Error. We are giving you a short date then.
Kindly, Lordship, my humble submission is that as the impugn order was passed, kindly come to place.
No, we have to hear.
Lordship.
He is not in a position to submit anything. That's why.
Lordship,
Otherwise,
complaint petition
we
is,
can pass over for the time being then. Can you inform the any counsel?
Thank you.
Please, Your Lordship. Revision petition, Your Lordship, filed for recalling of the NBWs and PNA. Last occasion, this honorable court directed me to produce the order whereby the case has been disposed of or kept in abeyance. I received a copy of order from download from the website. Copy to wherein the IO on report of the IO, Your Lordships, the learned court below has filed this case on 25/10/2024, Your Lordships. Sir, petition has been filed for recalling of the NBWs and PNA, Your Lordships. Annexer MNNO. And there is a 130 application has been pending, and I have paid substantial amount of the check amount, and I'm going to. This is there is a it is a
POCSO দেখুন, it is POCSO matter. Oh, into this is. It's a POCSO matter. It's a POCSO.
No. It's 130 recalling of criminal evidence. Criminal revision petition 453.
453.
So recalling of the NBWs and PNAs. So recalling of the NBWs and PNA, I have submitted one or the order copy, whereby the learned court below has kept in abeyance of the case, Your Honor, order dated 25/10/2024. Last portion, Your Honor. On the report of the IO, Your Lordships, the last portion that according to the case of the accused of Sri Bhaskar Gogoi stand filed till his appearance or his arrest by the police on the strength of pending NBWA or until further order. So matter is
Other the other order sheets you have annexed already.
Yeah, other orders is annexed. Annexer MNNO, where M is NBW has been issued. Subsequently, and PNA has been issued, and annexer O and 17/9/2024. PNA has been issued, and on 25/10, the court based on IO report of the IO, my case has been stand filed till my appearance. So I may be allowed to appear before the learned court below on 25th, Your Honor. Since similarly other cases also this honorable court directed me to appear on 25th by quashing the setting aside all the orders. And already it's a compoundable offense. I'm going to ready to pay the entire amount. So I may be allowed to appear before the learned court below, and the learned court below proceed as per the law. That's why I am required. On 5/11/2024. According to Your Honor, this is an order. It is like this. Duta question है कि NIT case. This is Your Honor.
My learned founder with your lordships, 14th bench asked an order, but here only direction is given to APN because since PNA has been issued, so the learned court is directed to issue decide as per law when he will appear.
That is how I require.
Only till appearance, my lord, that is kept.
On 25th, I will appear before the learned court below and satisfy the learned court below. And since I am paid the substantial amount, and the rest of the amount I will pay.
This is to yesterday he has given.
The day before yesterday, I had given this order, similar order.
What is your submission?
Since my submission is my case of I had appeared.
In that case?
Yes, because other cases, my lord, protection can be, but here, my lord, since PN has been issued, my lord, there are some decisions, settled decisions, my lord, by the Honorable Supreme Apex Court. And when, my lord, the PNA has been issued, my lord, he has declared as an offender, my lord. So protection under the law cannot be given to him. So in that case, my lord, only he can appear, my lord, and the trial court will decide, my lord, as per law. As per law.
Since a compoundable offense, and every opportunity it will be compounded, you know. It's a compoundable offense, and I will pay the entire amount of
Because a process has been issued by the trial court, it cannot be quashed at, my lord, at a go, my lord, because without him.
No question cannot be.
Yes, my lord. Only thing he wants to appear, let him appear.
I will appear
and trial court will decide, my lord.
Since the coordinate court has already been taken, an opportunity has been given to me on 25th. So that opportunity in other cases, no, sir?
Heard Mr. H. Borwa, the counsel for the petitioner, 55, and also heard Mr. M. P. Goswami, the learned additional PP appearing on behalf of state respondent. This is an application and a section so. Next para, it is submitted by Mr. Borwa, the counsel for the petitioner, that so what is the ground you have taken? Why you could not appear?
Medical ground, yellow. Annexer H 33 and Annexer I. During this period, since I have been in undergoing medical treatment for my entire backbone has been collapsed, Your Honor. I could not communicate with the even my advocate also. Since I am residing in Dhemaji and a case is pending before the Tinsukia court. That is why, because non-communication and as well as the due to lack since these medical issues, I have to visit.
You are suffering from spondylosis only.
Spondylosis and another backbone problem is there also.
That is the backbone.
Lumbar spondylosis.
This is the lumbar, yes.
And septicemia,
lumbar joint is there only.
Because some he is coming from remote area.
Lots of persons are there who are having spondylosis and
the thing is that
living a very normal life. Me also, I also have. Everyone is having.
He is a remote coming from remote area, Dhemaji district. So he will appear on.
Spondylosis cannot be a question.
On 25th, I will appear.
So and so, it is submitted that due to his illness only, he could not appear before the learned trial court below. And but earlier you were appearing.
Oh yes, I already appeared and bail.
Earlier he was appearing, and the case was also at the stage of evidence. For his illness, he even could not contact with his counsel, and for that reason only he could not appear before the learned trial court below. However, at present he is ready and willing to appear before the learned trial court below, and he is also ready to pay the entire amount, enter the entire check amount in question. Accordingly, he submitted that one more chance may be given to the present petitioner to appear before the learned trial court below and to contest the case accordingly. First. Next para. Mr. Goswami, the learned additional PP, submitted in this regard that he may be directed to appear before the learned trial court below, but the orders cannot be quashed as the court had already issued the PNA against the present accused petitioner. Next para. Considering the entire submission made by the learned counsel for both sides, materials on record, and also considering the submission made by Mr. Borwa that there is a probability of compromise of the case as he is ready to pay the entire check amount. Considering this, In view of this, the petitioner, it is the opinion of the court that the petitioner may be given one more chance to appear before the learned trial court below and to contest the case accordingly. In view of this, the petitioner is hereby directed to appear before the learned trial court below on or before within 15 days from the date of order. Until then, the execution of NDWA may be suspended. So you are giving 15 days time. Within 15 days, you
On
appear.
25, I will appear under your lordship. Lost. Deeply
Yeah. Setting aside of orders are not there, but only you are allowed to appear before. Until then, only the execution of a warrant be suspended.
And
state.
Oh yes.
It's a state bill लिखो and the if within the period he did not he does not appear before the learned trial court below, the order will automatically stand vacated.
NBW and PDA.
Yes. Disposed of at the motion stages.
Please, Lordship. My lord, this matter, my lord was pleased to hear yesterday, but due to the my lord directed to file the amended cost title, my lord, that we have done today, it's on record, I guess. So, my lord, my case is very simple, my lord. I filed I'm a opposite party in a DB proceeding, and I filed evidence in affidavit of D3, the defense witness number 3, my lord, on 1811. After filing the defense evidence, my lord, my whole evidence was expunged due to I took steps, my lord, for an adjournment. Only after filing the evidence, my lord. So that was the case, my lord. On 6/3/23, the learned trial court, my lord, page 47, that expunged my evidence, and accordingly I went before the appellate court. That is learned sessions of Shivsagar. My lord, that appellate court also upheld the order, my lord. So, my lord, since I have already laid my evidence, so I may be given an opportunity, my lord. Expunging my whole evidence is not, my lord, fair, my lord.
It's a case of POCSO.
No. It's a DB proceeding.
आपको भूल के ऐसे ये तो कार है ये तो कोर होस्ट ये तो यार है 56
Yes.
Cost type.
Cost type.
I mean,
Oh, we forgot to.
ये तो की POCSO matter ये तो यार है Petition number minimum है
455
ये तो ठीक है ऐसे हाँ ये तो ऐसे ये तो कम पैसे ये तो की because it is the number of this one is only 455 some mistake is there. In fact, one POCSO matter is also tagged with this one. Yes, you are the
I'm the opposite party.
Respondent, yeah.
Yes, I was the opposite party in the DB proceeding and petitioner here, my lord. So, my lord, I introduced 3 witnesses, my lord, D1, D2, D3. So, for D3, my lord, evidence in affidavit was filed on 18/11/2022. Then the next matter was fixed on 16/12. And on that day, learned presiding officer was absent, my lord, on leave. Then it was fixed again on 19/1 and then again 14/2. 14/2, my lord, defense evidence of D2 was allowed, but my evidence, my lord, my evidence was expunged. Because, my lord, I filed a petition, my lord, showing my reasons. I'm a lady, my lord. I have got some other personal, my lord, household works, my lord, and I'm an independent witness. So, my lord, only that reason, my lord. The learned trial court says the reason is not satisfactory. That's all, my lord. My lord, you find that order at page 47. Since I have already laid my
and
evidence.
against that order, you filed an appeal.
Yes, we went to the appellate court. My lord, appellate court also upheld mechanically, my lord. That's my case, my lord.
Where is the appellate order?
That is at order is at 58, my lord. Page 58, judgment at 59. In fact, the learned appellate court has itself stated, my lord, there is no provision of expunging evidence. And since I have already filed my evidence in affidavit, my lord, so I think, my lord, this is a bit hyper-technical approach, my lord. Needs to be corrected, my lord. Next date, my lord, on 16/12, the cross of DW2 is yet to happen, my lord. On 16/12, it is fixed.
Yes, bro. You're
That is a formal
part.
Formal. My lord may dispose of, my lord, or my lord may issue notice till the next date. The proceeding has to be stayed, my lord. Next one, please. Yes.
But when your prayer for DW2 was allowed, on the earlier the DW2 was already expunged.
No, DW3, my lord.
DW3 was expunged on which date?
On 6/3/2023, my lord. Page 47.
And thereafter, what had happened after 16/3?
16/3, my lord, also DW2, my lord, cross did not happen. He was a ill, my lord. But we filed another petition on 16/3, but that was also rejected, my lord. That is, my lord, that order is at 49. Actual page, my lord, at page 50. 49 is a type copy, my lord.
After 16/3, order of 16/3 only you.
I went to the appellate court.
But during that period, DW3 was already expunged.
Already expunged. So appellate court
So
also.
The case is still at the stage of cross evidence of DW2.
DW2 and yes, 2. 2 is yet to happen, my lord. On 16/12, it is fixed. And DW3, my lord, is an independent witness. He is not related in relation to the petitioner hearing, my lord. He is an independent witness, a neighbor, my lord. And her evidence is very vital.
Heard Mr. R. Chakraborty, the counsel for the petitioner. Also heard Mr. R. J. Borwa, the learned additional PP. For the state is 1 or 2? 2.
2.
State respondent number 2, who is also a formal party. In pursuant to order dated 19/11/2024. The amended cost title has already been furnished. Stop. This is an application under section 528. 528 of DPNSS. Against the impound order dated 13/8/2024 passed by Lanes Session Judge Sibsagar in criminal appeal number 12/1 of 2023, whereby the order passed by learned SDGM M. Najira in Miss TV case number 1 of 2020, dated 16/3/2023, is confirmed, expunging the evidence of DW3. It is submitted by Mr. Chakraborty, the counsel for the petitioner, that after completion of the evidence of the PWs, they have filed the evidence on affidavit of 3 DWs, and accordingly the date was also fixed for their cross-examination. DW1 was already examined.
Already filed.
Accordingly,
Cross-examination also complete.
The DW1 was cross-examined, duly cross-examined by the others, by the respondent side. However, the adjournment had to be prayed for cross evidence of DW2 and DW3. In how many occasions you prayed time?
My lord, I prayed first, my lord, on 16/12. On that day, the PO was on leave, my lord. Then on 19/1 and again on 14/2. 2 dates, my lord. 3 dates, my lord. On 16, PO was on leave.
But your thing, your DWs were also not present.
She was absent, yes. On 6/3, she was absent, my lord.
No, not 60. 16/12.
Yes, we took steps, my lord. We took steps.
Thereafter, in 3 occasions, that is on 16/12/2022, 19/1/2022.
23, my lord. 19/1/23.
No, sorry, 19/1/2023, and 14/2.
14/2, my lord.
14/2/23. The adjournment had to be paid due to various reasons. And on 16/12/2022, the PO was also, and on 16/12/2022, the PO was also on leave. But on 14/2, your impound order is at 47, no?
Yes, my lord. That is 6/3/2023, page 47. Then again 16/3, my lord, page 49.
But on 6/3/2023, the another petition for adjournment had to be filed for cross-examination of DW2 and DW3. But DW2 and DW3, wherein the learned trial court below had allowed the petition prayer for DW2. However, the prayer for DW3 was rejected as it was not found satisfactory, and the evidence of DW3 is accordingly expunged. On 16/03/2023, another petition was also filed for cross evidence of both the DW2 and DW3, and prayer for DW3 was also rejected as his evidence was already expunged. Against the said order, the petitioner preferred an appeal before the learned session judge Sibsagar, but the learned appellate court also passed a very mechanical order and dismissed the appeal, affirming the order passed by the learned trial court. It is next part. It is submitted by Mr. Chakraborty that there was no negligence or laches on the part of the respondent. However, due to various reasons, the 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 prayer for cross evidence of DW and the prayer for adjournment had to be made for cross evidence of DW2 and DW3. DW3 is a very vital witness for the petitioner as she is not related to the parties and is an independent witness, and hence her evidence is very vital for the petitioner. Full stop. If the DW2 is not allowed to be cross-examined, the petitioner there will be prejudice on the part of the prejudice may be caused to the petitioner side as she is the only independent witness for the petitioner. He further submitted that the case is still at the stage of cross evidence of DW2 and date has been fixed on 16/12/2024 for cross evidence of DW2. Mr. Chakraborty further submitted that the DW3 will accordingly appear before the learned trial court below for recording his cross evidence if one more chance is given to the DW3. Next paragraph. Considering the submission made by the learned counsel for both sides and materials on record, this court is of opinion that for the ends of justice, one more chance may be given to the DW3 for his cross-examination, which may be one of the vital witness for the petitioner side. Accordingly, the order of expunging the evidence of DW3 dated 6/3/2023 and 16/3/2023 passed by the learned SDGM M. Nazira is hereby set aside and quashed, and the order passed by the learned session judge so and so is also accordingly set aside, directing the learned trial court below to give directing the petitioner to appear before the learned trial court below with the DW3 for recording his or her cross evidence along with the DW2. The learned trial court below will accordingly record the cross evidence of both DW2 and DW3 on the next date fixed, on the next date as already fixed. With the above observation, the present revision petition stands disposed of at the motion stage itself.
Highly obliged.
That being 5.
Dispose of 5. And then 5 bonus.
May I please, Your Lordship?
Yes.
Is a quashing petition, Your Lordship, challenging the order of the executive mayor at page number 39, Your Lordship. The date, Lordship, 21/5/2024, Your Lordship, where the learned executive magistrate, Your Lordship, attached land measuring 4 bigha 1 katha 10 lessa, Your Lordship. Now, the disputed land was attached, Your Lordship, due to a dispute arising between two individual parties, Your Lordship. And the proceeding has been drawn, Your Lordship. The order has been passed under Section 107 of the CRPC, Your Lordship. Now, Your Lordship, respondent number 2, Your Lordship, is a formal party, Your Lordship, have initiated proceeding, Your Lordship, under Section 145 and 146, Your Lordship, claiming that 4 bigha land was possessed by them and some tea cultivation was done by from very initiation by them, Your Lordship. It is a dispute between petitioner and respondent number 1, Your Lordship. It is a dispute between very individual parties, not at public at large, Your Lordship. Now, Your Lordship, my crown to challenge this order, Your Lordship, that whether the landed executive magistrate have the power, Your Lordship, to draw a proceeding under Section 145 or 146, if, Your Lordship, it is not apprehension of public peace and tranquility, Your Lordship. Because, Your Lordship, if Your Lordship kindly see, Your Lordship, with due respect, Your Lordship, the objective behind incorporation of 145, 146, and 107 in the CRPC is very extraordinary, Your Lordship. And that can be used at a time of emergency, Your Lordship. Now, Your Lordship, in this case, Your Lordship, the dispute between petitioner and petition respondent number 1 is very much relevant and very much revealing from the judgment itself, Your Lordship. So I'm challenging on that ground, Your Lordship. Otherwise, the individual have the remedy, Your Lordship, before the civil court, Your Lordship. Specific relief act is there, Your Lordship. Injunction is there, Your Lordship. And for this, Your Lordship, without taking much time of this honorable court, I am relying on a judgment, Your Lordship. It is of Honorable High Court, Your Lordship. This Makbul Hussain versus Saidur Rahman and second Lordship. Here, Your Lordship, I am reading the relevant portion, Your Lordship. It is the second paragraph, Your Lordship. Disturbance of public order is to be distinguished from acts directed against individuals which do not disturb the society to the extent of vibrating a general disturbance of public tranquility. If a party illegally and forcibly occupies the land of another people, may be shocked and even mentally disturbed, but the life of the community may keep on moving, keeping peace with the even tempo of life of the community. If by the act of disposition even tempo of life of community is disturbed or jeopardized, it may be a case of disturbance of public order and tranquility. The acts of private parties which affect their personal rights and obligations only but do not disturb the even tempo of the society are merely private feuds for which action may not be necessary to be taken under Chapter 10 of the Code of Criminal Procedure. Section 145 of the Code clearly states that to assume jurisdiction of the magistrate must be satisfied that the dispute is likely to cause a breach of peace. It is not a breach of mental peace of the parties, but apprehended breach of peace in the locality. Ordinarily, a person disposes of property must sue for recovery of specific immovable property under Section 5 and 6 of the Specific Relief Act. And if there is threat to dispose him, he should institute a suit to obtain injunction. These are forums establishing the right of the litigants. A proceeding under Section 145 CRPC is therefore an extraordinary provision to grant extraordinary relief when there is likelihood of breach of peace in the locality. The final order of magistrate is subject to the decision of the civil court. So, Your Lordship, this getting of judgment, Your Lordship, but the case is in the motion stage, Your Lordship. So I'm not willing to take much time of this honorable court, Your Lordship. But my humble prayer at this occasion, Your Lordship, this is the notice may be issued, Your Lordship, and the impugn order, the effect of impugn order may be stayed, Your Lordship, till next returnable date, Your Lordship. That is my humble prayer, Your Lordship.
Receiver is also appointed now?
Receiver also appointed, Your Lordship. But if Lordship kindly see the page number 40, the judgment is reflecting, Your Lordship, without mentioning that there is a breach of peace between of public, Your Lordship. There's no such order, Your Lordship, in that regard, Your Lordship.
Plus, in the last part of the order,
Lordship.
DOC so and so is monitored to supervise the entire process.
Lordship.
And submit report accordingly to this court on or before so and so.
Lordship.
As the issue is the rightful position of DL could not be ascertained by the court, both the parties are ordered to approach the competent civil court.
Civil court.
Seeking further justice in matter. So
Lordship.
he has already instructed you.
Instructed
the
me
the disputed land will get automatically vacated after receipt of the final order judgment of the civil court.
Yes, yes. But
That
now
is there only.
Yes, yes. But the thing now, my grievance is to that extent, Your Lordship, the disputed land has been attached, Your Lordship, under 107. But
It is under your position now.
It is my position, Your Lordship. It is under my position. But it is the case between, otherwise my ownership is there, Your Lordship. I have proper title, Your Lordship. I have proper position of the over the land. But Your Lordship, under 107, Your Lordship, whether the learned magistrate has the jurisdiction, Your Lordship, to draw a proceeding, Your Lordship, between which is dispute between individual parties, Your Lordship. Because the power is very much extraordinary, Your Lordship. Incorporation of this section, Your Lordship, my humble praise to that extent, Your Lordship.
Heard MS G. Bora, the learned counsel for the petition. And also heard Mr. You are formal party. Yes. Heard Mr. R.J. Borwa, the learned counsel, learned additional PP for the state respondent number 2. This is an application under section 528 of BNSS seeking quashing of the order dated 21/05/2024 passed in MR case number 257 of 2024 by the Executive Magistrate Koliapur, Nagaon. Issue notice to the respondent to registered AD. No formal notice is required to be served on respondent number 2. However, the extra requisite copy may be served during the course of the day. Next para, heard on interim prayer. It is submitted by Ms. Bora that it is a dispute between two private personnel, that is the petitioner and the respondent number 1, and hence there cannot be any question of hampering the peace and tranquility in public peace and tranquility, though the Milan has been attested by the learned magistrate by its order dated 21/05/2024. She further submitted that the land is still under the possession of the present petitioner and accordingly prayed for stay of the order dated 21/05/2024 till next date of listing. She also relied on a decision of this court passed in Criminal Division number 101 of 1986 dated 23/1986, wherein also it is observed by this court that there cannot be any order of attachment unless the community as a whole is disturbed or jeopardized. Next para, considering the submission made by the counsel for the petitioner and that the execution of order dated 21/05/2024 passed by learned executive magistrate so and so in case number so and so be stayed till next date of listing. List accordingly after this.
Much obliged, Lordship.
Okay, then now question is that motion is there of 61.
May I please, Your Lordship? This is the petitioner is in custody since 2 years, 4 months, and 20 days, Lordship. Earlier rejected on Lordship 10,
My lord,
9, 10.
in this case, my lord, yes, in this case, my lord, scan copy received, my lord.
Yes, but I mean, your state is appearing. You are appearing here.
Yes.
Scan copy has already been received. It's a NDPS or?
Yes, Lordship, commercial quantity, Lordship. So the earlier rejection order is page number 39, Lordship. Order 9/10/2023. As per earlier order, Lordship, one direction was given by this one court, Your Lordship. That is page number 52, Lordship. Last paragraph, Lordship. May I, Lordship? 42, Lordship. Last line.
Yes, yes.
However, the learned special judge is.
No, what is the issue now? How many, is there any other witnesses examined?
Out of the 6 prosecutor witnesses, already 6 witnesses have already been examined.
7
Already
out of 7, Lordship.
Now, my lord, the settled report, my lord, that was as on, my lord, 17/8/2024.
17/8.
After August, month of August, my lord, there is no status report now. That has to be, my lord, called for.
Obviously call for. Otherwise, as per yours, out of 7 numbers of witnesses, 6 were examined. Then it's
And in the my lord, other rejection order also, lordship has specifically.
6 months. 6 months was given.
If my lord, 7 witnesses, out of 7 witnesses have already been examined, my lord. But the trial is almost, my lord,
Almost over, almost.
Last 1 year, Lordship, no witnesses has been examined, Lordship.
Then you call for the present status report.
But that may be called for.
Yes, from where it is up to 17/8.
It is up to 17/8, my lord.
17/8 only.
8.
Oh. But the order was passed on 9/10/23.
Yes, Lordship.
Acha. Anyway, status report, present status report will be required. We're giving you a short date.
Sure.
We'll try. From where it has to come?
Aminga, Lordship.
Huh?
Aminga.
Aminga.
This is the Ramingaon.
You are Mr. A. Rahman.
Yes, Lordship.
Heard Mr. A. Rahman, the counsel for the petitioner, and also heard Mr. R.J. Purva, the learned additional people, so and so. It is submitted by Mr. Borua, the learned additional people, that though the status report is received, it is up to only it is not updated, and the last date was not updated, and the status report is of only 14/8/2020. 17/8/2020 when I got full stop. Accordingly, he submitted it. Present status report will be required to see the progress of the case. Prayer allowed. Learned additional PP will accordingly take steps in procuring. Oh, it will come from the raised dinner. So they list the matter accordingly for. No, list the matter. When it can be listed then?
1st of December.
Date may be fixed.
Date may be fixed. Third only, I'm listing right. 3/12/2024. Registry is accordingly directed to call for the present status report of the case. So 3/12 is fixed.
50.
সেইটো ঠিকে আছে the question is that the CBI transfer forcing it CBI counsel also correct then করবে yes sir yes yes
Met your lordship. Met your lordship.
yes
But your lordship, the NDPS, but this person, my lord, he was one Alto car, my lord, local passenger. Alto car, it goes from this place to local, my lord. So he simply paying 100 rupees. He has just, my lord, got into the car. In the car, what driver was there, ultimately some contaminants was, my lord, it was found. Thereafter, your lordship, kind of FIR is paid. I come to page 16.
If, just a second
Page 16. Scan copy, call it is also come, my lord.
just a second the earlier matter from out of same FIR most probably I don't know for the same accused or that is also not known but your present petitioner name is Abdul
Monaf.
Monaf. Now, one has already been disposed of by the court of Justice Nandi.
This
now we are practicing that. That's why I'm just asking whether it should be placed before the appropriate bench or not.
If is it disposed by one bench, I
Yes,
think.
one bench is already
But
disposed.
whether this same FIR might have done.
Because yet here, yes, most probably same FIR.
But
Note is there. Note is there.
Notice there, madam.
Huh.
Case number, maybe the original case number. Huh?
Case number 2.
Madam, let us verify, let it come tomorrow, madam. Let us verify, madam.
Total yes, again the same FIR.
Same FIR.
FIR is of your FIR is
My FIR is
Rattabari?
a special NDPS case number.
No, your FIR name
Yeah,
is
FIR is Rattabari PSN 1
of 2024. Same.
But the name of the person, madam.
No, now we are practicing.
No, name of the accused.
No,
name of the petitioner is not.
that
Yes.
out of same FIR, one matter is been disposed, then definitely the matter
It will go
other
to that
matters has to
bench.
be before that bench. Yes, it has been disposed of.
But the name is the an accused name, madam, not just name. Petitioner's name, which are disposed of mine.
Petitioner's name will definitely different.
No.
Your
sir.
petitioner is different.
Just a name I want to know whether it is there or not. Mine.
Name.
Name of the petitioner who earlier accused this honorable court. Mine. That which were disposed of. Who was the petitioner, madam? Just. Huh?
এইটো to dispose হৈ গ'ল এই same FIR কাৰণে আহিছে আপুনি কনফাৰ্ম হৈ লওক
The petitioner নাম তো নাই নেকি? That is just fine. Oh, Niagan Nasa.
same FIR
Yes. Same affair.
same Rattabari 1 of 2020
Yes. তুমি হোসেন
for appropriate
তোমার
bench.
নাম লিখুন
Tomorrow, day after tomorrow, when it can be.
Submitted. Therefore,
So it is CS submitted, so it was closed.
Oh, I don't know now what is the
My learned
now
friend
one
there-
out of same FIR, it has to be
No,
before one
that
court
is,
only.
if it is disposed negative, here in view of the above, Sakshi submitted, Mr. So and so.
Because all are SARSI submitted only now. These are also all are charges.
Let us see the notification, madam. I think there is a notification, madam. Huh?
Notification is there.
Okay.
From notification is since we are practicing these things,
My
that's why
lord,
I'm just
I
asking
see.
you.
Now, if it is practicing, I have nothing to say.
Yes.
About that.
That's why, but it was just when I saw this note, then only it has come to my notice. If it would have been pending, then it is okay.
Right.
If pending case is okay, but one disposed, that matter will be different. That's why.
Only because I have been told that if it disposed on merit, my lord.
That I
then
cannot
it's
say,
so.
but already
But I do not
disposed
know
of
what is the practice, my lord. If we know
practice is there only.
whether all the cases or the case which was disposed on merit or anyway, let it come day after tomorrow, my lord, in the appropriate bench. So then we will see, my lord.
We're fixing it. If it comes again discord, then it's okay. No, nothing to. I don't have anything to say. List before the appropriate bench. It is the duty of the registrar to see these things. In fact, they are. This is the notification by the High Court from the High Court itself.
Yes.
So now practice is in that manner only that once
It
one
is a
is disposed
practice,
by
not a
the out of FIR, one case is disposed by one bench,
Right.
then definitely the other matters will come before that bench only. That is the practice. I don't know what is there. Anyway,
I am also not aware, my lord.
in the meantime, the matter may be clarified. I'll ask the registry also today.
And to list
Whether
according,
there
my
is
lord,
any-
because in
yes.
custody, my lord. That's
Yes, that's why I know. He's in custody since when?
257 days, my lord.
Oh.
325 days.
325 days.
And nothing against him, no whisper against him, my lord.
Oh. Did I list before appropriate bench on day after tomorrow? We can take it. We're fixing it on 22. If it comes again before this bench, we'll split it. This before appropriate bench on 22. And in the meantime, I'll talk to the registry today
My
itself.
Obliged.
If you're saying that
I'm saying that
only
not on
merit,
merit.
not on merit.
Since it's a submission made by my lord and friend, the charge sheet submitted. Courts, in view of the charge sheet submitted.
Accordingly, it was
If I have been told if there is a different views, then it is sent to that same bench. Anyway, madam, this type
Okay,
of things.
we'll continue.
Let us see.
16 and 17.
And in this case,
Yeah, you are paying for 16?
Yes.
Mr. Konikor is for
I'm
17?
yes.
Out of same FIR?
Out of
Yes. Oh, charge is submitted.
Circuit number 120, 522, 522, 2024.
CS number 522.
Public 2024. Date 28, 10, 2024.
28, 10.
21 or 22?
These are the cases relates to what? NDPS, same. NDPS?
NDPS.
Is there any confusion?
Yes.
522.
Disposed of. We have nothing to say. Disposed of.
Definitely, madam.
Disposed of. We are recording your name
Yes,
and
yes.
direction will be simple. Direction will be
Yes.
there. The appropriate
Yes, to approach the
application we
appropriate
have-
trial court, madam.
Yes. এটা করে দিব না দুইটা ওকে দি both the matters are
Much up.
19 and 20
Custody for 82 days, madam. And business paper filling both the cases, madam, to declare an FIR as not, madam. 141 of looking for case and madam 142. Madam, search is submitted in both the cases. 82 days in custody, madam.
what nature of case
POCSO and etc. This actual fact is not correct.
Huh?
Actual fact is not correct. So, POCSO
no
is
whatever it's a POCSO charge sheet has already been filed we should not interfere at this stage approach this court the learned trial court below with an appropriate application that may be considered your length of detention is quite reasonable 82 days so that may be considered we are passing the order in that line only it may be considered yes CS number
Madam, in item number 19, my lord.
item number 19 was it's different na matters
Two, madam.
Item number 19, search sheet number 123,
item number 19 search sheet number
123,
123
24,
24
dated 39,
309 2024
my lord.
in item number
Item number
18
20, my lord.
oh sorry 19 20
Item number 20, my lord, search sheet number 122. My lord, 122 of the 2024, dated 39, 2024.
It's a two FIR was there.
Yes, Lordship. For the same
Against
person.
the same person.
Same person. Like, he's a master or teacher of a school, Lordship. Some allegation is there, but otherwise, the headmaster of the school submitted an issued a certificate that no incident happened, Lordship, actually.
Oh.
Obliged.
In which? Both the matters. Your good name? I mean is referring for response number 2. In both the matters, we'll record your name.
Obliged.
Yeah.
Which one submitted method?
She has submitted.
Submitted being charge number 295.
295.
Public 2024.
24.
39/2024. 30.
Okay, we are disposing it a commercial matter.
May I please, the Lordship? Yes. My Lord, it is an NDPS case, my Lord, 22C. Petitioner before your Lordship was, my Lord, driver in the auto rickshaw, my Lord. And as per secret information, my Lord, this auto rickshaw was, my Lord, intercepted by the OC and IO, my Lord, and other police staff, my Lord. And when this auto rickshaw driven by this petitioner was, my Lord, intercepted by the police, this, my Lord, two passengers, my Lord, sitting in the, my Lord, back seat of the auto rickshaw fled away, my Lord. Then, my Lord, police admittedly chased them, my Lord, and caught, my Lord, and after body search, my Lord, this, my Lord, contraband was recovered from their body, my Lord. At that time, my Lord, petitioner was never, my Lord, suspected involved in this case. Therefore, he was not interrogated.
He was the driver.
He was driver, my Lord. He was not even disturbed, my Lord, arrested, my Lord. He was as if, my Lord, bona fide driver. He was allowed to go, my Lord. And, my Lord, entire, my Lord, investigation, my Lord, fairly gone, my Lord, and charge sheet was submitted, and he was never been disturbed, my Lord. Now, my Lord, after charge sheet, my Lord, he appeared, my Lord, and he was arrested on the basis of, my Lord, the statement of the...
No, he was not interrogated, not disturbed, but CS was submitted against him.
Against him, my Lord. Because, my Lord, this, my Lord, as per record, my Lord, now he has received, my Lord, these two accused persons, where from, my Lord, this contraband was recovered, my Lord, they stated that, my Lord, both of them, my Lord, stated that this petitioner is also involved with them, my Lord. Therefore, my Lord, I am, my Lord, relying on the statement, my Lord, most, my Lord, important statement of the, my Lord, the officer in charge of the case, my Lord, who intercepted the car, my Lord, and, my Lord, IO of the case, my Lord. I have annexed, my Lord, their statements also in my petition, my Lord, and there, my Lord, statement annexure 2, page 18, my Lord. There, my Lord, clearly stated that, my Lord, that these materials were recovered from the, my Lord, two passengers who fled away. Seeing the police, they fled away, my Lord, in the field, my Lord, and they were caught, my Lord, and materials were recovered from them, my Lord. And their statement, my Lord, kindly I, my Lord, beg to request your Lordship, page 18, my Lord. May I read, my Lord? I have given my name and address and stated above. My age is about 25 years. I am serving as Sub Inspector in Assam Police. Presently, I am serving at Hailakandi Police Station. My statement are that the on 16 to 2023 at about 4 p.m. the in charge of Hailakandi Police Station through a secret information could know that some suspected narcotic drugs are being carried in an auto rickshaw being registration number so and so from Lala to Hailakandi. Accordingly, having informant, the in charge of PS informed the matter to the higher authority, thereby taking our government vehicle bearing registration number so and so, accompanied with SI Bidan Das UBC so and so, Kishore Singh and half the section of ABPN staff and one section of so and so myself started towards the place of occurrence. As soon as reached to the place of occurrence, it was seen that the auto rickshaw bearing registration number so and so was coming from Lala, and there were 3 persons, including the driver of the auto rickshaw. When we tried to arrest them, the person seated in the auto rickshaw, having seen the police, fled away. Then the police staged them to arrest, but after a lot of
This
running,
is the statement recorded under 161.
161.
So what is the stage of the case at present?
My lord,
What is the stage of the case at
my
present?
lord, case is, my lord, appearance, my lord, charge sheeted, my lord.
Charge sheeted already?
Charge sheeted.
Charge has already been
Yes,
filed.
my lord. And my lord, same, my lord, in the line, my lord, OC also stated that, my lord,
Till now, no evidence is recorded now.
recorded, my lord. My lord, another aspect of this case is that, my lord, this, my lord, the main accused, my lord, where from, my lord, contraband was recovered, my lord, admittedly, my lord. He was, my lord, they were immediately, my lord, not immediately, my lord, after 90 days, they were released on bail, my lord. In this regard, my lord, I have submitted their bail order in my affidavit, my lord, running page 46 before the record, before your lordship. Annexure A, my lord, in my additional affidavit, running page 46 as in the record, my lord. It is, my lord, bail order dated 19/5/2023. And my lord, as per my lord order in the, my lord, third paragraph, they were arrested on, my lord, 16/2/2023, and they were released on bail, my lord, 19/5/2023, my lord. Bail bond of rupees 25,000 after 90 days, my lord.
Who is the special judge NDPS there at
Yes,
Hailakandi? Who is he?
My lord, name I have, personal name I don't know, my lord. Granted, my lord. Now, my lord, I have, my lord, annexed also.
Hailakandi special judge by district judge whom? Session judge.
Now, my lord, I beg to, my lord, rely some, my lord, judgment.
No, relying will be different.
District judge. And petitioner before the lordship is only, my lord, 19 years old boy, my lord. On that day, my lord, his father was not well, my lord. Therefore, he was driving the car of auto rickshaw of his.
Yeah. Commercial.
My lord, I beg to refer, my lord, page 53, order of this honorable court, my lord. Annexure C in my additional affidavit. Paragraph, my lord, he is more than, my lord, 4 months, my lord. Yes, my lord, he was arrested on, my lord, arrested on, my lord, 1/7/2024, my lord. More than 4 months. And these judgments are, my lord, that, my lord, only because of, my lord, statement of the co-accused, my lord, a person, my lord, may not be, my lord, punished, my lord. One thing, my lord.
My lordship may kindly come to my lord, page number 35, my lord, of the bail application. 35, my lord. The first paragraph, my lord. This is the charge sheet, my lord. Page number 35. My lord, page number 35, first paragraph, my lord. I'm just reading it. Last down 3 line, my lord. First paragraph. During interrogation of arrested accused person, namely Zahid Hussain Borbhuya and Jubraj Pandey, they stated that one Iqbal Hussain Borbhuya alias Ripon, son of so-and-so, village so-and-so, Hailakani is also involved into the case, my lord. Then, my lord, first, second, third, fourth paragraph, my lord. Page number 35, my lord. Sufficient evidence was found against the arrested accused person, namely Zahid Hussain Borbhuya, the number 2, my lord, Jubraj Pandey, son of so-and-so, and absconding accused person, namely Iqbal Hussain Borbhuya, alias Ripon, and they were involved with the crime, my lord. Accordingly, my lord, the accused number, my lord, this present petitioner, my lord, he absconded, my lord. And my lord, he was, my lord, definitely, my lord, it's a, my lord, organized crime, my lord. And if your lordship go by the statement of the, my lord, other accused person, because, my lord, other arrested accused person statement is very much necessary during investigation, my lord, because they have to be interrogated from their position, my lord. This, my lord, commercial quantity of narcotic drugs were recovered, my lord. Now, when they were interrogated, my lord, they have implicated this person. He is the person who supplied the contraband to them, my lord. That is why, my lord, he was shown absconder in the search sheet, my lord, and search is submitted, my lord. Later on, he was arrested, my lord. So, my humble submission, my lord, since the, my lord, search has already been framed, my lord. So, let the trial be proceeded, my lord. After, my lord, examining, my lord, 2-3 witnesses, my lord, because there are, my lord, 10 witnesses cited in the search sheet, my lord. 12 witnesses, my lord. After examining about 3-4 witnesses, if they does not implicate my lord, then, my lord, then there may be a case, my lord. Otherwise, my lord, it's a commercial quantity, my lord, organized crime, my lord. Although he has been, my lord, arrested on the basis of the statement of the co-accused, my lord, but the way, my lord, the implication, my lord, where the co-accused implicated him, my lord, that has to be looked into, my lord. Because there has to be someone, my lord, who supplied the drugs, my lord. Drugs recovered from the arrested accused person, my lord. He was the auto driver. He fled away. He was absconding.
No, my lord. Statement, I am relying on the main statement on the spot, my lord, is IO and OC, my lord.
Well, IO and OC, they have given a statement because they have, my lord, there was a, my lord, Nakaseki, contraband recovered, my lord, 2 persons tried to fly away, they were arrested. Now, my lord, when they were interrogated, my lord, that statement he has not perused, my lord. I have flagged the statement of the co-accused, my lord. Lordship may kindly peruse. It was written in Bengali, my lord.
Yes, my lord.
Recorded in Bengali.
To save their, my lord, way, my lord, they will definitely say, my lord. But in this case, my lord, my humble submission before your lordship, my lord, this is, my lord, genuine statement, IO and my lord, OC. On the spot, they recovered, my lord, and they intercepted, my lord. And as per secret information, they went to the place, my lord. And they categorically stated there, my lord, when they, my lord, signaled the, my lord, auto, my lord, these 2 persons fled away. And police chased, my lord, after a lot of struggle, my lord, they were caught, my lord, and from their body check, my lord, this contraband was recovered, my lord. And they never disturbed, my lord, this humble petitioner before your lordship. Of course, my lord, these 2 accused, to, my lord, find out their way to get bail, my lord, stated, my lord, against this petitioner before your lordship. But it is settled principle of law, my lord. This, my lord, as per the statement, only as per the statement of the accused person, my lord, this petitioner, my lord, may not be convicted, my lord, and this plea also may be.
Question does not arise.
No, Lord,
Trial has not begun.
My lord, I have also annexed one Supreme Court judgment, recent judgment, my lord. This is a short judgment, my lord, and it was also held, my lord, in the respect of similar case, my lord, that this Tupansing judgment can also be relied upon in the respect of, my lord, the regular bail, my lord, when accused before jail, my lord. And I have annexed this judgment, my lord, page 64, my lord. 64, my lord. Yes, my lord. My lord, paragraph 65, my lord, paragraph 8 is relevant, my lord. Page 65, paragraph 8. In this case, this nature, the respondent may be able to take advantage of the decision in the Tufan Singh versus State of Tamil Nadu, Supra, perhaps in the time of arguing the regular bail application or at the time of final hearing after conclusion of the trial, my lord. Now, my lord, I beg to, my lord, basing on this judgment, my lord, this honorable court granted bail to other accused person, page 53, lordship, kindly below. It is, my lord, page 53, annexure C, bail application number 965, 2022, Lorik Ram, my lord. It is, the order was passed 27/5, 2023. Paragraph 3, my lord, I beg to rely, my lord. Here in the, my lord, same line, my lord, page 55, this, my lord, truck driver was there, my lord, and there, my lord, co-accused, my lord, implicated them, my lord, driver, my lord. But it was found that, my lord, as per the statement of the police officer, my lord, it was found that my lord, he is not involved, my lord. Therefore, bail was granted. In my case also, my lord, as per the main, my lord, witness, IO and investigating officer. Yes, my lord.
It is seen that the truck driver, regarding the truck driver, last para, the finding of the investigating officer is, of course,
yes,
subject to final outcome in the investigation.
Yes, my lord.
Therefore, this court is of the prima facie opinion that the rigor of sections so and so are not affected in a peculiar backdrop of the case.
My lord.
But here the
Yes.
but here the question is the final outcome of the investigation is already before us. The charge sheet has already been filed.
Yes, my lord.
That is the difference.
Difference, my lord. But only, my lord, I am, my lord, still, my lord, I am relying on the statement of the, my lord, other, my lord, IO and OC, my lord. Now, my lord, lordship, another
Okay,
judgment.
we'll see to it. But the question is that the statement
Only-
of the seizing officer who made the statement before the IO, well, this was at the stage of investigation. In fact,
Yes, my
he chased those person.
Yes, my lord.
Recovery
I
was
am
there.
on that, my lord, only.
Recovery was there, and then
Yes,
his
my lord.
statement was recorded. He handed over the so and so, so and so.
Yes,
so and
my
so.
lord.
He was not the investigating officer, in fact.
Yes, my lord.
But during the investigation only, most probably as the Borwa has submitted, those things are come. Definitely, we'll see to it. We'll pass
My
it.
lord, none also, my lord, I have, my lord, last, my lord, one, my lord, page 57, my lord. This is the, my lord. 57, my lord. Annexure D, my lord.
Yes.
Here, my lord, paragraph, my lord, 57, page 57, paragraph 3, my lord. Submission, my lord, to, my lord, understand the background, my lord. Mr. So-and-so learned counsel arguing for granting bail submits that in view of the determination made by the apex court in the case of so-and-so reported in so-and-so, and my lord, this so-and-so judgment regarding value of the confessional statement recorded under section 67 of the NDPS Act. Such statement shall remain inadmissible even at the stage of consideration will. Therefore, in view of such settled position of law, petitioner is entitled for grant of bail. Now, my lord, the findings of this court, my lord, page 61, paragraph 14, my lord. May I read, my lord? Paragraph 14, my lord, page 61, that being the position that in view of the ratio laid down in the case of so-and-so, that the confessional statement recorded under section 67 of the NDPS Act 1985 will remain inadmissible in the trial of the offence under NDPS Act, and therefore such statement, more particular on the basis of confessional statement, voluntarily statement of the co-accused, cannot be ground to have a reasonable belief that the accused is guilty of the offence, my lord. Accordingly, my lord, bail was granted. And my lord, this case, my lord, petitioner before your lordship just crossed, my lord, 18 years, my lord. On that day, my lord, I have stated, my lord, in my petition, his father was unwell, my lord. Therefore, my lord, for earning livelihood, my lord, he, my lord, casually, my lord, came out for driving the auto rickshaw, my lord. And my lord, this unfortunately, this two bad men, my lord, entered his auto rickshaw, and police, my lord, simply arrested them, my lord. Of course, my lord, they will say, my lord, something somewhere, my lord, they are not involved, my lord. Only their for their statement, my lord, and they are no relation, my lord, their telephonic connection, etc. is not, nothing is revealed, my lord. They are only plain and simple, my lord, unknown passengers, my lord, and his mistake is that, my lord, they were picked up, my lord, and police, my lord, arrested them. He was not disturbed. Only for their statement, my lord, and he suffered a lot, my lord, and cases also, my lord, in the trial stage, my lord, and more than 4 months, my lord, he is in jail. And just, my lord, he is 18 years crossed. Kindly, my lord, maybe consider, he will face trial, my lord, and co-accused are already, my lord, granted bail by the trial court, my lord, rightly or wrongly, my lord. Both the passengers are granted bail by the trial court after 90 days during the investigation. I have an next one. Yes, my lord.
I don't know how or what ground he has done this.
Right
That's what
or
I was
wrong?
just searching for who was the session judge in fact.
Yes, my lord. Kindly, my lord, reply.
Time no more this is it equal to time was last item to go তাহলে এটা না লাগে বলে একটু পিছন হবো উপায়টা না সেকেন্ড হাফ কিন্তু মতো অলপমান দেৰিকে উঠে এই দিস ইটানাগৰ বেষ্টৰ লৈ তাৰপিছত অলপমান দেৰি হৈ
Lordship dispose of mother.
I'm going to dispose.
Item 23.
Well, the petitioner was arrested on 25/9. It was in 24 months. Today is 57 days. Allegation in the affair is that page 12 is the affair, that police team, my lord, conducting narco checking, my lord. And they have found some vehicle driver and related the vehicle some document is irregularity and violate the MB Act, my lord. And therefore police collecting the fine, my lord. And in the meantime, my lord, who is the person, my lord, collecting the fine did not issue the receipt to the person. Accordingly, my lord, the altercation was and debate was with the public and the policeman. And the present petitioner, my lord, his residence is near that road, my lord. And there was a gathering, my lord, he also come out. And he also take part in the debate, my lord. Admitted fact, my lord. And the public will threaten the police that what you are doing, my lord, we are going to file the complaint against you before the higher authority, SP or other, because you are collecting the money and keeping the some public 100-meter distance. Because talk with the every person separately. Nobody can hear that who is what is talking with the particular person, and he go and call the another person. These way the Naga checking was conducted. And when threaten the police, the public that we are going complain against you, then police, my lord, what happened? They have filed a case against some particular person. And as a result, my lord, some person was arrested, my lord. In fact, whole the story is concocted, my lord. And earlier, my lord, I have moved a bail petition before the Honorable Court, my lord, for 2 numbers of co-accused, my lord. Honorable Court for release, my lord. Why do you do it? And that time, my lord, the Honorable Court observed. And 47 days, my lord, they were in custody, and now is 57 days, my lord. So 10 days more and 3 days left to complete this period, my lord. So maybe very unfortunate case, my lord.
Do you have the injury report with you now?
Injury report is, my lord, there is no further injury. Because, my lord, allegation is that, my lord, he tried to snatch the, my lord, revolver, my lord, of the police officer, my lord, and, my lord, he taken, my lord, in fact. My lord, other police officers, they had taken him, my lord. And he was the, my lord, person, my lord, who was obstructing, my lord, duty, police duty, my lord. Because they were doing some regular checking, my lord. They were checking the, my lord, vehicles, my lord, my lord. This accused person, along with some other, my lord, they have
This present petition, name of the present accused petitioner is?
My lord, it is Atwar Rahman.
He is the person who snatched the arms, I
The
think.
arms, my lord, points out that one other police person, they appreciate this. That is the basic allegation against.
False allegation. Very unfortunate. Simple person without any weapon, nobody will mallet in general mallet stage mallet caught the police. Only the case of only defense of the policeman. He is 57 days in custody, man. He filed the anticipatory bail also, my lord. The honorable court rejected. Then I suggested he willingly surrendered, my lord. He willingly went to the police station, my lord, and surrendered himself, my lord, as per my suggestion, my lord. No police custody also will be required at the time of investigation, my lord.
Eta submission extra legal. One more submission. I'm giving you this one. In a on the other hand, Mr. Das did to Asayate. You write Mr. R.J. Borwa, the council, the additional PP. The Pakistan submission ticket. Yet Mazat Eta I have marked here. That only you, Mr. Borwa, further submitted that this is the present accused petitioner is the person who obstructed the police personnel in doing the narco checking, duty of the police personnel for narco checking, and he also snatched the arm of the police personnel, though he was subsequently apprehended by the other police personnel. Accordingly, he raised objection in granting this offense. It will hear you. Again, same thing. Okay, you are granting.
Only in that order there was 47 days.
57
days. Now
today.
57 days. And Alaka Magistrate, man.
Yes.
I'm obliged, man.
Item 59 of the supplementary list.
Oh, अच्छा, हाँ. 58, 59. 59. Okay. Coil not happen. The outer coil will go. It is already 11, 12 coils. Then this is the other. This was is here. 59 you are appearing?
For the NCB.
For the?
NCB.
Oh, अच्छा, for the NCB. Well, it comes in 9 here. M. Biswas was earlier, M. Biswas was there in fact.
Your Honor, M. Biswas was appearing for the petitioner number 2 and he has withdrawn the case for the petitioner number 2 and subsequently he has filed the item number 58. Alteration Biswas.
Now Mr. Biswas is appearing on item number 58.
58. And for 59, no one is appearing. From the last 3-4 occasions, no one is appearing.
A2 cancer, A2 cancer, কোনটো cancer? কোনটো cancer হয়? এইটো আগৰটোহে cancer আছিল। এইটো আপুনি আকৌ এইটো দিলে দেখোন। এইটো cancerটোহে দিলে। এই আমি cancerটো কল কৰিছিলোঁ। 2427. 52 হৈ গ'ল, 59 টো লাগিব মোক এতিয়া। 59 টো। উল্টা হৈ গ'ল। কোনে মাৰি আছে সেইটো 58 টো ইউ আৰ টেকিং দি 58 58 টো আপুনি মাৰিছে 50 টো উল্টা হৈ গৈছে 59 টো 58 টো গুচি গৈছে 2032. 2032. গুচি গ'ল এইটো 2032. 2032. এইটো উইথড্ৰ কৰিছে নেকি? 2033. No, he was earlier appealing for number 2 only.
Number 2. But he has withdrawn the case for the petitioner number 2.
He drawn for petitioner number 2. So now Omid Gop is still there or it's not here?
He's still there, but no one is appearing on his behalf.
Oh, acha, acha. You are appearing on behalf of or
I'm appearing on behalf of NCP for SCK.
SCK? Your good name?
K. Jain.
Mr. Hard, Mr. K. Jain, the counsel, appearing on behalf of Mr. S.C. Kyle, standing counsel NCB. Post up from the order dated 4/10/2024. It is seen that the Mr. M. Biswas, the learned counsel, who was appearing for the petitioner number 2, has withdrawn his name against the petitioner number 2 and already filed another bail application for the petitioner number 2, Harisaran Biswas. But no one appears on behalf of the respondent petitioner number 1, Sri Omid Gop, GOP, and thus he remained unrepresented. For ends of justice, let the matter be listed accordingly after 1 week. But who was appearing for 1 earlier?
Earlier, D. Bora.
D. Bora.
But they have given the NOC to the client, so their names were struck off from the cause list.
Oh. List after 1 week. We are listing after 1 week. Let us see. If he, again on the next week also he remain unrepresented, then maybe disposed of.
But item number 41, my lord. I think one of the issues may be allowed to withdraw with a liberty to file again, my lord.
41.
41. On criminal petition, my lord. Due to some technical defects, my lord. Quashing, my lord.
You want to withdraw it now?
Withdraw with a liberty to file again, my lord.
Part Mr. H.R. Chaudhary, senior advocate, assisted by your Miss
K. Burma.
K. Burma for the petition, and also heard Mr. R.J. Borwa, the learned additional PP. So and so. It is submitted by senior counsel Mr. Chaudhary that, as per the due to some technical issues, he wants to withdraw the same with a liberty to file afresh. Prayer allowed. Case is withdrawn or disposed of on withdrawal with a liberty to file afresh.
Obliged.
I'm sorry, my lord. Item number 24, lord. CD is not received. There is there, lord.
Huh?
Item number 24, lord. CD is not there, lord.
Item number 24. What was there?
Interim is there, lord.
Huh?
And before customer for the day, lord.
Interim was there? We have not reached the 24, I think. Case there you have received? Not received. As a CD not received, issue reminder. Interim be continued till next date of listing. When it can be listed? 6/12. Now 60, 61 was there. This will, what will happen at 2? I have one VC from Itanagar bench. I'll take it, I'll try to take the VC from my chamber only. Thereafter only this will go.
Right.
And in the morning I was asked to inform the standing council CBI. Yes, you are appearing?
Lordship, my senior counsel has also other matters in code number 20 and 18 at 2, fixed at 2.
After 2:10 to 15.
10-15 minutes, we can just
2:15.
inform him. I don't know, down here is insisting that he is behind the bar.
Yes, madam.
Sent for a considerable
Yes,
period. Most
yes.
of that may be the ground.
Yes, yes.
So let him come, we'll
Lordship,
hear
we
him.
have the bail matters at
We-
code number 18.
2:15
I don't know,
time
you
bottle.
just yourself. I don't know.
who is calendar electric articles Lordship, and from the one contextual side.
379
is the person who bought the foreign article.
Is this also registered under 411 or no?
379.
Only 379?
Only 379.
So further, not further, custodial interrogation may not be necessary.
Yes, properly in the investigation, his statement is recorded.
Mr. Equal, the learned counsel for the petitioner, and also had Mr. R.J. Okay, D.P. Kusami. Censor. This is an application of section 482 BNSS for so-and-so. In connection with so-and-so, CD receipt, fidelity hardwood. Mr. Goel, the learned counsel for the petitioner, submitted that the present accused petitioner is to be connected in the alleged offence. However, he already appeared before the IO after obtaining the interim bill dated 26/7/2024, and accordingly, his statement is also recorded under section 161 CRPC. He is still ready and willing to cooperate the IO in further investigation of this case if he is granted with the privilege of rearrest. Next paragraph, Mr. Gustami, the learned additional people submitted in this regard that the present the present petitioner has already appeared before the IO and his statement is recorded, and it is seen that he is cooperating the IO in the investigation of this case. First, next paragraph, considering the submission made by the learned counsel for both sides, materials available in the case diary, it is of the opinion of this court that custody interrogation of the present petitioner may not be required for the interest of the investigation. According to the interim 26/7 will become absolute on the same terms and conditions. Okay.
Deep.
32.
May I please your lordship? This is an application under 482.
Yes.
For Priya's bail, my lord. My lord, page 14 is the FIR.
3?
14, 1-4.
I want.
In this case, my lord, CD was called for, my lord. Now, my lord, may I read, my lord? Or you should read. সম্মান বিনীত নিবেদন এই যে মোৰ নাবালিকা বিয়ৰী সুস্মিতা সরকার হাইস্কুলৰ 6ষ্ঠ শ্ৰেণীত পঢ়ি থকা এজনী ছাত্ৰী যোৱা 10/8/2024 তাৰিখে সময়াবলী 2টামান বজাত স্কুল ছুটি হোৱাত মোৰ নাবালিকা ছোৱালীজনী ঘৰ আহি উপস্থিত হয়। উপস্থিত হোৱাৰ কিছু সময় পিছত তথা সময় আবেলি অনুমান 3টামান বজাত উক্ত স্কুলৰ সহকাৰী শিক্ষক শ্ৰী পৰিমল ৰায় মোৰ ঘৰত আহি মোৰ ছোৱালীজনীক তেওঁৰ ঘৰত আন কোনো লোক নথকাৰ বাবে তেওঁৰ ঘৰলৈ মাতি যায়। মাতি যোৱাৰ কিছু সময় পিছত মোৰ ছোৱালীজনী উক্ত শিক্ষকজনৰ ঘৰত উপস্থিত হয়।
উপস্থিত হোৱাৰ পিছত শিক্ষকজন তেওঁৰ ঘৰৰ ভিতৰত মাতি নি মোৰ ছোৱালীজনী স্কুলৰ কেপ্টেইন পাতি দিব বুলি কৈ মোৰ ছোৱালীজনীক 20 টকা দি বৰফ খাই আকৌ তেওঁৰ ঘৰত যাবলৈ কয়। বৰফ খাই পুনৰ মোৰ ছোৱালীজনী শিক্ষকজনৰ ঘৰত যোৱাত শিক্ষকজনে মোৰ ছোৱালী নাবালিকাজনীক পিছফালৰ পৰা সাৱটি ধৰি গুপ্ত অংগত হাত দিবলৈ ধৰাত মোৰ ছোৱালীজনী দৌৰি নিজ ঘৰলৈ আহে। This is the case, my lord. Now, my lord, section 7524 and section 10 of the POCSO Act provision. My lord, they are the closed door neighbor at the same time. And my lord, both the families are coming and going to their house regularly, my lord. And he is like a fatherly figure, my lord. My lord, this affair was written by the police, my lord. When the local people has taken the father to the police station, and this affair was lost. Initially, father was not willing to lodge the affair. That it is some misunderstanding. However, this affair was lost, my lord, and police asked him to appear, my lord. He did not appear because of the apprehension that he may be arrested in this case, my lord. Now he is before your lordship, my lord, for period bail, my lord. And in this case, informant also appeared, my lord. They have filed also affidavit, my lord. It is in the record. In the affidavit, my lord, they have denied the entire incident. My lord. We pray that, my lord, if when the affidavit is filed by the informant denying the entire incident, even if the case is charged sheeted, what will be the fate of the case, your lordship can easily presume, my lord. So considering that aspect, I may be given an opportunity to record my statement under what circumstances anything happened, madam. I take your lordship the affidavit filed by the informant. Kindly peruse it, my lordship will get the full picture of the matter. My friend is also appeared on behalf of the informant, madam.
Yes, Goswami.
Date of birth of the victim, your lordship, 13/1/2013, and was in the 182 section of BNS lordship. She implicated the petitioner. Another guard was examining her statement also recorded. She is also implicated the same thing. Which both such statement from the victim guard lordship. I can say it.
164 question.
164. It is 164.
161.
64.
161 একো নাই।
161 আছে।
আছে।
দুইটা আছে। না।
statement type is same. Touching only हो जाए ना. এইটো দে. একেবাৰে নহ'ব পাৰে.
8 to 3 years.
Minimum.
Education is system. ঘরে মাটি লেখা না। Another statement is also there also. Prior to that test, she also said in the same line.
My concern is, Your Lordship, at this stage, Lordship, anticipated bail cannot be granted to the petitioner, Lordship.
Yes.
He was a next door neighbor, man. Yeah, I was not there in Guwahati. I was in Guwahati at that point. And I came to know, man.
Very bad statement.
The statement touching is there, sir. I have seen it.
Very bad statement.
Touching is there. Can be case of section 8.
No, whatever. Being a teacher, if he does and teacher repeatedly, it's not one day. Not one day for 2-3 with 2-3 girls. He's repeated that offense every day, every alternate day. From a teacher, see. And on the last occasion, he told that I'll make you captain and come and do all these things. This kind of touches. Hard, Mr. Hard, Mr. S.C. Biswas, counsel for the petition, and also heard Mr. D.B. Goswami, the learned additional people, appearing on behalf of state respondent, and Mr. Your name is not here?
Yes. P. Kotoki.
No. P. Kotoki.
P. Kotoki is there.
We are on 35.
Well, my prayer before your Lordship is that.
Respondent number 2.
Achha, Mr. P. Kotoki is not there. Where? Oh, yes. Mr. P. Kotoki, so appearing on behalf of the informant. Full stop. This is an application under section so and so in connection with so and so. City receipt, same hard both side. Mr. Biswas, the learned counsel for the petitioner, submitted in this regard that the present accused petitioner is innocent and has not committed any such offense as alleged in the FIR. As per you, why the FIR was lodged by someone else?
Because it was, they are not willing to lodge the FIR, Father. Because it is not exactly what happened, my lord, it is very mysterious, my lord. My lord, it is the developed story in the FIR. My lord, put it because the 161 statement or 160 is under the pressure of the police or subsequently. And that's why when I am before your Lordship, I want to give my statement what happened actually.
The father submitted that the FIR was also not written by the informant by himself, and it was written by the police with some exaggerated and concocted story. However, he is ready and willing to appear before the IO and ready to cooperate in the investigation of this case. He further submitted that the informant is also not aware about the statement made in the FIR, and accordingly, the affidavit is also filed by the informant side, wherein it is stated that he has no objection if the bail is granted to the present petitioner. Next, Mr. Goswami, the learned additional PP, submitted in this regard that there are sufficient incriminating materials available in the case diary, especially in the statement made by the victim and 2-3 other minor girls under section 161 vis-a-vis 164 CRPC. Accordingly, he raised objection and submitted that it is not at all a fit case wherein the privilege of anticipatory bail can be granted to the present petitioner. Next paper. Mr. Kotoki, the learned counsel appearing for the respondent number 2 / informant, submitted in this regard that he is not aware about any such incident happened with his daughter, and they are the neighbors and living peacefully in the society, and hence he has no objection if the bail is granted to the present petitioner. Anticipatory bail. Next, hearing the submission made by the counsel for both sides, I have perused the case diary. First off, on the in the saying that the minor, not only the victim but the other 2-3 minor girls brought same kind of allegation against the present petitioner, which is also and it is further alleged that the accused petitioner was doing all these things with them repeatedly, not in not only in one occasion. Considering the materials available in the case diary and the statement made by the victim vis-a-vis the other minor girls, I do not find it a fit case to extend the privilege of prior's bail to the present petitioner. Accordingly, the same stands rejected. Your petition stands rejected.
Right.
Rama story, Monday I come to you.
34. Item 34.
34 CD was retained, na? It is already received on the 1311 and it was retained, I think.
Received on 11/11, yes.
Yes. Mr. A.K. Roy was earlier appeared for this, today they are not appearing. None appears on call for the. So what do you want to do? Because from 11/11 or 13/11, I don't know if the CD has been retained.
Retained. We send back the CD lordship for the investigation.
Was there any interim also? No.
No.
What nature of case this is?
For POCSO lordship.
POCSO.
Amicus may be appointed in this case.
Amicus was also appointed. Eh?
He does.
He does. He was also absent.
Yes. In the morning times he was here also. The fix a short date lordship, then I will retain the CD.
Okay. None appears on call for the petitioner. Heard Mr. D.P. Kusami, the learned additional people for the state respondent. The amicus appointed in this case is also remain absent. From record, it seems that the CD is received and it is retained from 13/11/2024. Let the matter be accordingly listed. Yes, so after 1 week, any date. 4/12, so and so. Till that, the CD may be retained.
35.
Wait, is allowed.
Yes.
Well, in this matter, my lord, the instruction must be obtained whether service is completed upon the respondent number 2, my lord.
Oh.
Yes, we have received instruction from verbal communication from the IO. So this is service. Service is complicated.
Service is complicated.
Amicus may be appointed fixes next date.
CD
is available.
CD received.
CD received.
Heard Mr. S.S. and counsel for the petition. Also heard Mr. D.P. Kusam, the learned additional people for the state respondent. It is submitted by Mr. Kusami that the services, that on the verbal communication, it is learned that the service is already completed on respondent number 2. Full stop. However, no one entered into appearance on behalf of respondent number 2. Accordingly, the registry is hereby directed to appoint one amicus. Nam to ami reading it already. May be appointed. One amicus may be appointed to represent the respondent number 2. Further, the CD in the further it is submitted by Mr. Kusami that the CD is already received. You want to retain it or what?
Next week,
Next week, any day?
29th, ask of
29.
29/11. Retain the case diary next date of this day.
Highly obliged.
Except for 60 and 61.
61 till now they are not applied. One letter was 2 p.m. was paid.
Yes.
When they
49.
Upgraded item 49 for orders.
Why it is in order column?
My lord, in fact, perhaps for non-service on the respondent 1, my lord.
1.
Yes.
My lord, recently this notice was issued, and last it was, my lord, listed on 14/11. My lord,
Yes, you were asked to obtain instructions regarding the service of notice on respond number 2. Yes. Do you have any?
my lord, before the learned additional PP, my lord, respond, may I very briefly place my case, my lord? Because, my lord,
Just
today...
I want to see
my
what
lord,
it is.
correct.
Yes.
Even after some time, let's say, I will complete the report.
Okay. Okay, then he is right.
My lord.
Yes. What do you want to submit?
My lord, my respectful submission in this case is the impugn order 18/9/24 rejecting my application, my lord, for further cross-examination has resulted in prejudice to the accused and denial, my lord, of a fair trial. My lord, what has happened? My lord, the petitioner is presently facing the trial. 7 witnesses have been examined, my lord, and now the remaining witness of the prosecution, 8 is awaited. 8, my lord, is the investigating officer. Now, at this stage, my lord, we had submitted an application, filed an application seeking recall of PW 1 and 2 for further cross-examination. Now, that, my lord, prayer was rejected by the impugn order 18/9/24. Now, your lordship will see from the materials on record, initially, my lord, the charge was framed under Section 4 of the POCSO Act. 4, my lord, is the punishment prescribed, and the substantive offence, my lord, under Section 3. After examination of PW 1 and 2, the learned trial court, having found, my lord, there are ingredients of Section 6, my lord, it was altered to, my lord, Section 6, POCSO. Now, already 1 and 2, my lord, had been examined. So, from the provisions of the POCSO Act, your lordship will find that Section, my lord, 3 and 5, the punishment under 4 and 6, are two different and distinct offences, man. Those are two different. And if your lordship goes through, my lord, the punishment prescribed are also different. The maximum punishment under 4, my lord, is life imprisonment. And under, my lord, 6, my lord, he may face death penalty. So, my lord, our, my lord, defense was that in absence of, my lord, effective cross-examination of PW 1 and 2, which had already taken place prior to alteration of the charge, my lord, it may prejudice and he may face a death penalty. So, in that event, my lord, accused will face severe punishment, my lord, in absence of a proper cross-examination. And that will, my lord, in fact, my lord, will amounting to, my lord, deny a fair trial. And your lordship is aware, fair trial is implicit, my lord, under Article 21. It is his constitutional right. And if your lordship comes to, my lord, the initial charge, page 17, this was, my lord, under 4, annexer 2, page 17. Then, if your lordship comes to the altered charge, page 29, annexer 5, at the top of the form, it is with charge with one head, altered charge form, and the third para, you Konokboro is hereby charged under Section 6 of POCSO Act 2012 shall be tried by this court on the said charges. Now, on the earlier occasion, my lord, when this honorable court wanted to see the formal order, whether there has been a formal order, my lord, passed by the trial court, my lord, in fact, I could not produce it. So, therefore, by way of the additional affidavit, which is brought on record today, my lord, the formal order is placed before your lordships, my lord. And the formal order your lordship will find in the additional affidavit, the order passed by the trial court at page 58, continuation page, my lord. This is 14/3/23. Already PW 1, my lord, and 2 have been examined, my lord. And it indicates, my lord, here also. Accused is present, PW 2, 3 are examined, cross-examined and discharged. Already 1, 2, 3 examined, my lord. Perus CR, heard learned counsel for accused and learned special PP, considering the evidence adduced and birth certificate of victim girl produced today, charge is altered to Section 6 of POCSO Act. Accordingly, charge under 6 of POCSO Act is framed, which is read over and explained to accused, to which he pleads not guilty and claimed to be tried. Now, the last part says my lord, defense had declined to further cross-examine. Learned Special PP and Learned Defense Counsel submitted that they want to proceed with evidence already recorded and do not want to re-examine witnesses. Now, at a subsequent and later stage, my lord, having realized that it will really cause prejudice, my lord, the application was filed. Now, if your lordship comes to the operative part of the order, impugn order, on what ground, my lord, my application has been rejected? The page, my lord, it starts from page 44, and I take your lordships to the operative part at page 51. Oh, sorry, my lord, page 52. The penultimate paragraph, the big paragraph 1, my lord. When I reviewed the case's circumstances, lordship has got it, my lord, I conclude that the defense was unable to provide any justification for the acceptance of the prayer in accordance with guidelines established by the Honorable Apex Court for proving or disapproving a request for recall of witness. Now, this is, my lord, the reasoning. It is only mentioned that the conducting counsel omitted to ask a few crucial questions, but no attempt was made to identify this omission or explain how they would have affected the fairness of the trial or prejudiced the accused in the petition or at the hearing. So therefore, my lord, essentially, what the trial court has held while rejecting the proceeding to reject, my lord, the application, that the questions are not identified. And it is also not explained how this omission would prejudice me. My lord, with all respect and humility, I submit, my lord, that this reasoning may not be correct. Because the moment, my lord, I disclose my questions, my lord, I will be prejudiced. My lord, the prosecution, my lord, witness will become wiser. And therefore, my questions will become redundant, my lord. It will have no force. And your lordship is aware that unless the application, my lord, is rejected on the ground that this is vexatious, or it is filed, my lord, to delay the trial, or for, my lord, to defeat the ends of justice, my lord. Normally, your lordships, my lord, allow such kind of petitions, my lord. And the trial court has not rejected on either of these grounds. It does not say that it's a vexatious application. It does not say it will defeat, my lord, the ends of justice, or it will delay, my lord, the proceedings. Those are not the grounds at all. My lord, the error of the defense counsel or the mistake of the defense counsel to effectively cross-examine is a ground approved by the Supreme Court, my lord, in some of the, my lord, cases. And in this respect, my lord, I place one judgment of the Honorable Supreme Court that application has been allowed on identical, my lord, terms. This is, my lord, 1999 6 FCC 1110. I take your lordships directly to para 8, my lord. This is also a case of recalling of witness under 311. Para 8, my lord, the lines 8, my lord, 8th line from the bottom. It starts as no party in a trial. Lordship has got it. No party in a trial can be foreclosed from correcting errors. If proper evidence was not adduced or a relevant material was not brought on record due to any inadvertence, the court should be magnanimous in permitting such mistakes to be rectified. After all, function of the criminal court is administration of criminal justice and not to count errors committed by the parties or to find out and declare who among the parties perform better. Then if your lordship again come to para 9, the very same decision in Mohanlal Swami Soni versus so-and-so, which caution against filling up lacuna, has also laid down the ratio. It is therefore clear that the criminal court has ample power to summon any person as a witness or recall and re-examine any such person if the evidence on both sides is closed, and the jurisdiction of the court must obviously be dictated by exigency of the situation, and fair play and good sense appear to be the only safeguards, and that only the requirements of justice command the examination of any person, which would depend on the facts and circumstances of each case. So therefore, even after the closer, my lord, of the evidence, the further examination is permitted. Here, my lord, the prosecution evidence has not even yet concluded, my lord. Defense is yet to start. So therefore, my lord, my case rests on a better footing. And your lordship will appreciate, my lord, in absence of a cross-examination, my lord, there is possibility I am susceptible to a punishment which can, my lord, travel to death penalty. And that will be amounting, my lord, to, my lord, denial of a fair trial. So this is, my lord, my ground. And this ground is not vexatious, my lord. It is potential for me.
Yes, what is the report?
We have tried to communicate with my concerned police station, my lord, but my lord, the service report is not complete, my lord. So let the, my lord,
Not
report be
complete.
complete. They have not received the notice, my lord.
Then I more this registry for this amount of this. Register for this more this registry this.
You to one actually. But you know, let it come, my lord, next week, my lord, because this, my lord, appearance of the, my lord, information is necessary in case of POCSO, my lord.
My lord, in that regard, I have a reservation. It absolutely is a lordship discretion. But regarding the service, my lord, of notice in Deepak Nair's case, that is relatable to bail application. Here, my lord, I am only asking for further cross-examination. Your lordship, my lord, what I am trying to say, if my lord the IO, if it proceeds, my lord, then my petition become infructuous. So next date is 7/12, my lord. If your lordship fixes up, my lord, next week, I don't have any, my lord, objection to that. But I think, my lord, if the matter again does not reach, or my lord, if it is not served, so better your lordship will kindly, my lord, pass some interim order or some stay order. Then let the, my lord, complainant.
So for that, I have objection, my lord.
Yes,
I just point
I
out,
leave it
my
to-
lord,
I leave it to him.
I just point out, my lord, 2-3, my lord. I just take your lordship to my lord, page number 42, my lord. This
Are you
petition has been,
replying?
this application has been filed, my lord, with mala fide intention, only to my lord, fill up the lacuna, my lord. Because, my lord, they want to further cross-examination two witnesses, that is PW1 and PW2, the parents of the victim, my lord. Lordship may kindly see the, my lord, Annexer 42. This is the application filed by them, my lord. Annexer, my lord, page number 42, my
No,
lord.
okay, before hearing to it, I just want to submit it. You want to make submission in this regard or you want to reserve it?
Yeah, then I'll submit my part, my lord.
I am not
Being the, my lord,
insisting.
Being the, my lord, state, my lord, we'll place our submission, my lord. But before that, my lord, service has to be completed. My humble
That's what I'm
submission is that.
asking you, whether only because that his part has almost I have heard. If it can be now, as per your instructions, it is not yet served, or what is the report?
Not received, my lord.
Not received.
Not received by them, my lord. By the concerned police station, my lord.
Concerned police station.
Yes. That is the, my lord, my learning has obtained instruction, my lord. Because he has taken the service to registry, my lord. Registry forwarded to us, and we forwarded to the concerned OC, my lord.
I have also submitted extra copy to the
When it was forwarded?
It is forwarded, my lord. But they have not received, my lord.
In which police station this is?
This is, my lord, Dispur, my lord.
My lord, in fact, if I am not mistaken, it has to be routed through the Mukalmua PS. The address is of Mukalmua.
Mukalmua.
Yes. And I don't know whether Dispur, my lord, is the proper police station or not.
Why to Dispur it is
The
gone?
case is registered, my lord, under Dispur police station.
Okay,
my lord.
okay. No problem.
And this, my lord, informant, my lord, they hails from, my lord, Sorthebari, Borpeta, my lord.
Oh, sorry, Sorthebari. Sorry, PS Sorthebari.
Then obviously it will not be served.
Definitely, my lord. So, my lord, will require some time, my lord.
If it is there from Satyabari, then definitely it will not be case. Through research. In charge? No, but the officer in charge Satyabari is already given. It is to Satyabari police station, not from Dispur police station. Kuntu case.
Step second, my lord.
Huh?
We have forwarded, my lord.
No, you have forwarded. You have inquired the matter in the Dispur police station only.
Sorthebari.
No, just now you have said
No,
that
it's
Dispur police
Satyabari.
station is not.
My lord, let it come on, my lord. Day after tomorrow.
No, no. If it is gone through, suppose it should be through judicial police station. That is the Satyabari police station. Enquiry, but there in the Satyabari police station only. Dispur is no function there. Because as per his submission, when it is matter is
7/12.
7/12.
Yes.
Prior to that, let us
Yes,
that
my
be fixed.
And, my lord, secondly, my lord, even the IO examiner also, my lord, if this application is allowed, my lord, then also, my lord, they can be cross-examined. There is no bar, my lord. Even after examination of the, my lord,
investigating officer also, if it is petition is allowed, my lord, then they can be my lord cross-examined. If lordship allows it.
Can be, but the
That
question is
different
there
aspect.
may be some corroboration, contradiction may be there in
Absolutely.
the statement of the IO that has to be brought in the record.
Absolutely.
That may be one of the aspects for examining the or cross-examining the earlier
Yes,
to the
exactly.
examination of
Lordship is
the
correct.
IO. That is the only point.
Let it
Otherwise,
come-
also I have seen the order. That therefrom, it is seen that most probably only for the considering the age of the victim that has been altered, because the file passing the order, one line is there that the age of the victim is considered. Most probably that may be one of the reason why it is altered to 4 to 6. I don't know, rest apart, I don't know what is there. Repeated allegation may be there, or she may be a minor, less than 12 years also. That may come also.
So let it come on Monday, my lord.
Next Monday.
Monday.
Monday, if it is not possible, then let it be on Tuesday, Wednesday.
Tuesday, Monday.
Better to fix it on Tuesday so that you can. Party had Mr. A.
26
Yes, I think 40. It will go ahead. Oh, it's a year now. We are at 40. 40.
49, my lord.
Oh, sorry, 49. Had Mr. Acquittal the counsel for the petition. Also had Mr. R.J. Burwa, the learned additional PP Swenson. It is submitted by Mr. Burwa that so you made an inquiry. Till
My
now,
lord.
they have not received.
My lord.
In
We'll
Dispur,
inquire from the Sothebury police station, my lord.
you have to inquire.
Yes, because my lord, the residence of the informant has been mentioned in the under
Yes,
Sothebury
yes,
police
yes,
station.
yes.
Because the case has been registered under Dispur, my lord. But my lord, whether if
Don't
the
inquire in the
state-
Dispur in Sotabari only, because it has gone through jurisdiction police station. In fact, submitted that no matter was inquired in the Dispur police station. It is seen that the notice is not yet received by the Dispur police station. Also, however, on perusal of the record, it is seen that the address of the informant is of Sotabari police station, under Sotabari police station. Accordingly, accordingly, it is submitted by Mr. Borba that he some time may be granted to inquire as to whether the service is completed on response number 2, which was sent to Sotabari police. List accordingly on Monday. You're not on Tuesday.
Tuesday, 26.
26. 26. List accordingly.
Reputable license.
Typing item 9.
Yes. Who is appearing now? For text, who is appearing? Mr. Borwa is appearing.
Item
9. 9.
Basically, this.
No, okay. You are appearing, Mr. Borwa? Okay.
Basically, this case was filed on 2 grounds.
Huh?
First of all, while taking cognizance by the learned trial court, did not meet the requirement under section 202 subsection 1 of CRPC. That is because the petitioner resides beyond the territorial jurisdiction of the learned trial court, but section 202 subsection 1 of CRPC was not complied with. So in this regard, I would like to place the judgment of honorable.
Only one submission, my lord. They are probably my lord, income tax council, my lord. Standing council of income tax. my lord.
That's what we are saying in the morning
That
hours.
is right, my lord.
But he is saying that as the complaint was lodged by one government officials,
My lord.
most probably state is therefore made party.
Said after income tax.
Income tax notice after serving notice of
So the card is our 50 billion no. 50 billion no. Income tax to do.
Actually, who is the standing councillor?
Official be
Income tax standing, who is the standing councillor? Oh, SC Kyle. Yes.
Let me be clear, my lord.
Since morning, it was, I mean, kept as part-time being because of the confusion whether the, now you're saying that you're going to appear.
And matter relates to matters what I found, matter relates to income tax department.
Oh, yes, income tax.
Allegation is under section 276D and 277. It is alleged in the complaint petition that the petitioner has evaded tax, did not submit his return by saying, giving false statement, and further statutory notices were not complied with by the petitioner.
Yes.
So-
Now, just want to see that if it is state is there, then whether standing counsel income tax will appear or we have to make party.
Let him that it cannot be directed to survey copy, my lord. Today it's a matter maybe come up tomorrow, day after tomorrow, my lord. They have to serve to us, my lord. Let them serve to the standing of the income tax.
In complaint petition, lordship, complaint name is specifically mentioned. Though his designation was also mentioned.
Whose designation?
Complaint.
Yes, that's what you are saying, that he is a
Yes.
government official, but the matter relates to income tax, in fact. This allegation is the evading of tax and all. So if standing counsel is there, most probably they are ready. Huh?
Income tax department is the complaint.
Income tax department is the complaint.
So, my lord, let him be clear.
Yeah. Yeah. Heard Mr. EMS, the learned counsel for the students, and also heard Mr. RJ Purva, the learned additional PP appearing on behalf of state respondent. However, it is submitted by Mr. Purva that the case relates to income tax, and the complainant is also an employee of the income tax department, and accordingly, it submitted that the standing counsel of the income tax department may be supplied with a copy of the petition to appear on behalf of the state respondent. Accordingly, the petitioner is hereby directed to furnish a copy of the present criminal petition to the standing counsel income tax, and registry is also hereby. But how can it be directed? They are the party, they are not the.
Let them, my lord, let them file survey copy, my lord. And let the matter come up day after tomorrow, my lord, Friday.
Sub copy. Matter may be released the matter accordingly after tomorrow's 22nd. There are lots of matters been fixed or what? Huh? There are lots of matters in 22nd. 29/11. She is suggesting 29/11. Will it be on 29/11?
Lordship, in trial court, next date is fixed on 29/11. So
29/11.
Before, if on Friday.
Next Friday, this Friday. That's what she is saying, that lots of matters have been fixed in fact. 27 corridor from. Yes. Will it be 27?
Highly.
For admission, item 10.
अच्छा 60 61 पर बोलो
Left resolution. Here in this, my lord, I am challenging order dated, my lord, which is page number 24, my lord, taking cognizance.
24.
Page 24, my lord. The cognizance has been taken under section 63, 64, 1, 66, 68A of the Copyright Act, my lord. My lord, the charge sheet has been filed, my lord, after 14 years. So it is barred by limitation, my lord, under 468 2C, my lord. And while taking cognizance, my lord, no delay has been explained by the IO in the charge sheet, my lord. And while taking
charge sheet is filed after 14 years.
14 years, my lord. I will come to that, my lord. So 473 is there, my lord. But there are prerequisite, my lord, condition which has to be satisfied, my lord. That the delay has been satisfactorily explained by the IO, my lord, or the informant, my lord, while taking cognizance, my lord. And apart from that, my lord, nothing has been, no reason has been assigned why cognizance has been taken, my lord. So, my lord, your lordship come to page number 8, that is the FIR, my lord.
Yes, which para? Which page?
Page 8, my lord. The date of the lodging FIR, my lord, is 25/7/1999.
FIR is of page?
Page 8, my lord. That printed form, my lord.
Huh.
My lord.
When
The
it was
top line, my
launched?
lord.
25/7.
25/7/1999, my lord. Now your lordship come to the chart sheet, my lord. At page number 19, my lord. This is a type copy, my lord. The original one, my lord. Page number 22, my lord. The chart sheet number, my lord. 3837/14, dated 3/8/14. So after 14 years, the charge sheet has been filed, my lord. The maximum punishment prescribed, my lord, under section 63 of the Copyright Act, my lord, is up to 3 years, my lord. 64, 1 and 66 are, my lord, procedural and no payment provision, my lord. 68A, my lord, which prescribes, my lord, maximum penalty for 3 years, my lord. So within 3 years, the charge sheet has to be filed, my lord. So it has not been done, my lord. And there is no explanation while taking the cognizance, my lord. That is my case, my lord. The cognizance should not have been taken against me, my lord. So I am relying on some judgment, my lord. The first one, my lord, state of HP versus Tara para 7, my lord. I am relying on para 7, my lord. May I read the relevant portion, my lord? Para 7, Section 473 confers power on the court taking cognizance after expiry of the period of limitation, if it is satisfied on the facts and in the circumstance of the case that the delay has been properly explained and that it is necessary so to do in the interest of justice. Obviously, therefore, in respect of the offences for which a period of limitation has been provided under section 468, the power has been conferred on the court taking cognizance to extend the said period of limitation where a proper and satisfactory explanation of delay is available, and where the court taking cognizance finds that it would be in the interest of justice. The discretion conferred on the court has to be exercised judicially and on well-recognized principles. This being a discretion conferred on the court taking cognizance, where the court exercises its discretion, the same must be by a speaking order, indicating the satisfaction of the court that the delay was satisfactorily explained and condonation of the same was in the interest of justice. In the absence of a positive order to that effect, it may not be permissible for a superior court to come to the conclusion that the court must be deemed to have been taken cognizance by condoning the delay whenever the cognizance was barred, and yet the court took cognizance and proceeded with the trial of the offence. Next one, my lord, it was from the FS court, my lord. Next one, my lord, our high court, my lord. Gauri Kanto Bora, my lord. Para 8 and 9, my lord. I am relying. Para 8, my lord. Though the trial court has ample power to extend the period of limitation by condoning the delay as per provision of section 473 of CRPC. But this power is required to be exercised by specifically indicating the reason for which is necessary to do so in the interest of justice. However, such exercise of power under 473 by the trial court cannot be presumed. If the order of the court is silent in the instant case, apparently there was inordinate delay in taking cognizance of the offense, but neither the first informant explained the reason for filing an FIR after 5 years of occurrence, nor the trial court at the time of taking cognizance examined the delay and condoned it. In Chandu Pharmaceuticals, so and so, my lord, Honorable Supreme Court observed that the court should not have taken cognizance of the offences after expiry of the period of limitation as prescribed under Section 468 CRPC. And this power to condone the delay under Section 473 CRPC can be exercised only when the court is satisfied on the fact and circumstances of the case that the delay has been properly explained or that it is necessary to do so in the interest of justice. Para 9, my lord. Section 473 CRPC no doubt has given ample power to the courts to take cognizance even after the drift of statutory period. However, this discretion can be exercised only after completion of requirement laid down therein. The situation is that the court must be satisfied on facts that the delay has been adequately explained by the prosecution or extension of time is necessary in the interest of justice. These two fundamentals are sine qua non to extend the period of limitation. But here in this, my case, my lord, nothing has been explained, my lord. And next one also, my lord, para 11, same thing, my lord, by our High Court. So, my lord, after 14 years, delay should have been condoned, my lord, while taking in the cognizance, my lord. So it has not been. That is my case, my lord. So it,
Yes, please.
In this case, my lord, may I take your lordship to my lord 470 of the Code of Criminal Procedure, my lord. Well, 473 of this Code of Criminal Procedure.
Yes.
Extension of period of limitation in certain cases. Notwithstanding anything contained in the foregoing provision of this chapter, any court may take cognizance of an offence after the expiry of the period of limitation. If it is satisfied on the facts and it is circumstances of the cases that the delay has been properly explained or that is necessary to do so in the interest of justice, my lord. In this case, my lord, the FIR was filed, my lord, in the year 1999, my lord. As charge sheet was submitted, my lord, in the year 2014, my lord. And, my lord, cognizance was taken, my lord, by the under Chief Judicial Magistrate, my lord, on 2/5/2018. Now, my lord, the impugn order, my lord, which he has challenged, my lord, that is, my lord, the second impugn order, 25/2019, my lord, in page number 30. Page number 30, my lord, the second last paragraph, my lord. Now, in the above case law cited by the learned counsel of the defense, the subject matter pertains to that section 500 IPC, whereas in the case in hand, the subject matter is that of under section 63, 64, 1, 66, 68A of the Copyright Act, where the punishment is graver than that of the case referred to. So, in the instead case, it is found to imply that the learned CGM, while taking cognizance, must have resorted to section 473 CRPC while taking cognizance even after expiry of the period of limitation. That is why his petition was his this is Probably, my lord, is appeal, my lord.
No, no, no. Before the trial court, my lord, we
Trial
have
court, my
prayed.
lord. That case petition was rejected, my lord.
After taking cognizance, after
So
our
this is the order is passed by whom?
my lord, by the trial court, my lord. We have prayed before the trial court, my lord. So trial court has rejected our prayer, my lord. That's why we are before, I am before your lordship.
So before taking cognizance or after taking cognizance?
After taking cognizance, my lord.
You have filed?
Yes, my lord. Because I have pointed out that this should not have been done, my lord. But it has been
His
reflected that
application was to drop the proceeding, my lord.
yes, my
To delay.
that has been rejected, my lord.
Mr. Bora, is there anything in the order? Cognizance order, which is the cognizance order?
Page 24, my lord. 2528.
24.
My lord. Nothing is there, my lord. May I read, my lord? Page 24. 2528, my lord.
Yes.
2018, my lord. Case record containing charge sheet is put up. Seen the charge sheet submitted by the IO against accused Tapas Bhattacharjee on court bail under section so and so, and enclosing one seizure list. Cognizance of offence is taken against the accused Tapas Bhattacharjee under section so and so after going to the materials of record. So 473 delay, nothing has been explained. By taking for the interest of justice, there must be a speaking order, madam. Nothing is there, madam. So the cases which I am relying on.
But the whether delay has been explained in while filing the charge sheet by
No,
the
my lord.
prosecution?
My lord, kindly come to the charge sheet, my lord. Page number 19, the type copy and the original is there, my lord. Assamese Vernacular, my lord. Nothing is there, my lord. Page number 20, the brief of the case, my lord. Nothing is there.
I feel it is in that there is no explanation by the IO also regarding the delay, why delay was there. Because after long 11 hours, the charge sheet was filed in fact. And the order you have pointed out in page number 30, it's a suppose a presumption by the court that the learned CJ might have taken the resort of 473. But the fact is that this such kind of thing is not available. Anyway, we'll pass the order. Is there any other submission? Okay, we pass the order. The order to give a power and or poll or oh yes, yes. Your good name? Vidas. M.I. Kasna? Yes, any submission from your side? Yes.
Your Lordship, according to my part, Your Lordship, I have given FIR in the year 1999, and also to that investigation part, Your Lordship, some CDs were collected that were kept illegally from the accused person. And it was came under my banner name, Your Lordship. That is MR. Yes.
MKD Films.
MKD Fleet.
Now,
Films
as
name,
per
Your
my
Lordship.
instruction, this firm is no more in existence. Because
It was the year of 1999 while
earlier,
the
my lord, there was
FIR has
big
been
reels,
registered.
Now it is digital, my lord. Regarding movies.
After going through, Your Lordship, he was arrested, Your Lordship, and there are sufficient materials has been recovered from his possession.
My lord, part of the merit, my lord. I am not onto the merit.
Apart from Your Lordship, that Your Lordship, the charge sheet has already been submitted, but that has been delayed. And in Annexure C, Your Lordship, that was forwarding report. It was also already mentioned, Your Lordship, that from his home, that is paragraph ground of arrest. In paragraph 3rd, Your Lordship, in line paragraph 1, line 3, 3rd line, Your Lordship, released Hindi film that so and so at his home illegally for selling them in market. ISK Borwa along with other staff deputed to search the house of the said Tapas Bhattacharjee and inquiry the matter. Accordingly, I along with SI BD Sharma and other staff searched the house of Sri Tapas Bhattacharjee, son of late Jayanta Bhattacharjee of Karun Nagar, ABC, PS Discord, and found 5 numbers of VCR, 1 master cassette of newly released Hindi feature film, so and so, and 4 number of recorded video cassette of so and 10 number of blank video cassette from his possession, which were duly seized in the presence of witness, Your Lordship. And also in page 16, Your Lordship, second line, Your Lordship, I would like to read, Your Lordship. Sri Tapas Bhattacharjee has re-recorded the same illegally and is supplying throughout Northeast region. Accordingly, dispute PS case, so and so, already case has already been registered against him, Your Lordship, because he is the supplier. Throughout Northeast region, he is dealing that illegal act, Your Lordship. That is my humble submission. Deeply oppressed.
We have to devote police into organization for কালি ভিতৰত কাম successfully যাবলৈ চেল কৰি ৰাখি থৈ দি দিম আৰু নহ'লে অৰ্ডাৰ বুলি ডেটা ৰাখি লাগিব এনেই চেল কৰি থৈ দিম কি নহ'লে চেল কৰা মানে দীঘলীয়া মাথা নহয় চেল কৰিব অৰ্ডাৰ বুলি ৰাখিলে টিউটোৰিয়েল বেলেঞ্চ ৰাখি থৈ দিব কেনেকৈ অৰ্ডাৰটো মাৰিব Fix for order. For delivery order. Take it up with you. On kiman nasi. Dito sa dito ba? Then I can put it up. to try to pass the order today itself, but I don't know. There are some lots of matters are pending.
My lord, your
So
lordship
it will be fixed for delivery of order within
lord,
this
my
week. I'll pass the order.
No problem.
May I please, your lordship? Here, your lordship, one item that has already been passed, your lordship, item number 34, where my name has been in that order sheet, your lordship, recorded as amicus curiae, but in the cause list, your lordship, my name has not been reflected, so I am not aware of that matter, your lordship, pertaining to item 34. So kindly, my name may be reflected in the cause list in the next date, your lordship.
Who took the dictation?
Item 34.
Item 34.
We have rectificated as a non-appearance to the process of work. It was also not present.
Oh yes, non-appearance is already recorded.
Kindly, my name may be reflected in the cause list, your lordship, as amicus curiae.
नाम तो reflect कोई नहीं करेगा.
Okay. Keep your best.
Item 12.
Lordship, may this matter may be adjourned for today.
Item 12.
Yes. Lordship, may this matter may be adjourned for today.
You are appearing as a legal aid?
Legal aid, I am looking for. There may be fixed lordship. This is the order from October 2023. No maintenance has been paid till that lordship. They have challenged the order of maintenance lordship.
They have challenged the order of maintenance.
Maintenance.
No maintenance has been paid.
Lordship.
Why?
Lordship,
Marriage, etc. are admitted. Marriage is admitted.
Pending lordship.
It's pending.
Husband has, this petitioner has filed it.
At a request made by the learned counsel for the petitioner, cases adjourned. However, considering the submission of Mr. A. Google, the learned legal aid counsel, it is seen that since the filing of the present petition, no maintenance has been paid to the respondent side. Please the matter accordingly. After one week or 2 weeks,
Lordship, after 1 week.
please accordingly after. Well, still we are trying to give a short date so that matter may be heard.
Thank you.
13.
May I please, your lordship? This criminal appeal is filed appeal against acquittal, my lord. Against the interim judgment and order dated 9/10/2023 passed by the learned session judge Kangub Amin Rao in criminal appeal number 3919, where the learned session judge acquitted the respondents accused person from the offence under section 447/34 IPC and 324/34 IPC and setting them at liberty, my lord. My lord, in this case, Srimati Archana Dekha is the complainant, my lord. First, she lost an FIR, my lord. And the central point of this FIR is that there is a dispute, my lord. The accused person blockaded the backside part of the complainant side. And when the complainant and her husband was absent, and on that day, the accused person blockaded the backside of the complainant area, my lord. And the complainant and her family members used to the part as a urine and latrines, my lord. And on that day, my lord, when the FIR was lost, there was quarrel, my lord, between the complainant and the accused person regarding the path, my lord. And the complainant brought the Gaungura to Gaungura, and Gaungura advised them to accused person to remove the blockade, my lord, from the backside. And they did not obey the instruction from the Gaungura. Thereafter, they again quarrel, my lord. And in that quarrel, the accused person entered trespass in the house of the complainant and caused
Now, here,
Martin.
against the said judgment, you have filed and preferred an appeal also, no?
Yes, my lord. Learned Judicial Magistrate First Class Hazo. The case was first time registered as a. I'm going to the Annexure 1, my lord. First time. After lodging the Azahar, case was registered under section 448, 320, 294, 323, 326, read with section 34. Thereafter,
Initially, you were convicted.
Yes, my lord. Initially, they were convicted. Both two accused persons, Diganto
In
Deka and
appeal,
Madan
you
Deka.
are acquitted.
Then the complainant, accused person, then prefer appeal to the session judge, my lord.
Where they got the acquittal.
Then again, the session judge thereafter acquitted them, my lord. Then again, the complainant proceed to the honorable court, my lord, for against the judgment for the acquittal, my lord.
Yes, Burba, anything?
Opposite parties, my appearance is necessary.
No, regarding admission, anything you want to say?
My lord,
Let him appear, my lord, whether service complete.
my lord.
No, not it.
My lord, service is complete, my lord. There was a condemnation petition. Condemnation petition opposite Modern Deka and Diganto Deka advocate appeared, my lord. They also gave objection, my lord. And the delay was condoned, my lord. Thereafter, criminal leave petition was heard, my lord, from the both sides, and criminal leave petition is also allowed. And today is the admission stage, my lord. They should appear, my
But otherwise, yeah, we cannot say at this stage whether they are going to appear in the appeal or not. That is the issue. Leave petition, they appear, file objection, it's okay. But appeal, whether they are going to appear or not.
But their name may be shown in the corpus, my lord.
On the basis of that.
On the basis of that, my lord. So regarding my lord, appeal against acquittal, my lord, scope is very limited, my lord.
Very limited. Very limited.
Anyway, my lord, let the both party be heard, my lord.
Heard Ms. B.R.A. Sultana, the counsel, legal aid counsel for the appellant, and also heard Mr. R.J. Buru, the learned additional people appearing on behalf of state respondent. This is an appeal against the order of acquittal. Passed in. This is an application under section 378/482 CRPC against the order of acquittal dated 9/10/2023, passed by learned session Judge Kamrup Amingao in criminal appeal number 39 of 2019 under section 447/34 IPC and under section 324/34 IPC. It is next right submitted by Ms. Sultana that the respondent number 1 and 2 were earlier represented by their engaged counsel while hearing the petition. And the notice was duly served on both the respondent number 1 and 2. On perusal of the record also, it reveals that both the respondent number 1 and 2 were duly represented by the learned counsels and they were heard while passing the order in the leave petition. Next paragraph, considering the submission made by the counsel for both sides, the appeal is admitted for hearing. Registry is hereby directed to reflect the name of the learned counsels who represented the respondent number 1 and 2. As shall be called for, this matter accordingly after 4 weeks. Okay, please.
My lord, today's appeal is admitted, my lord. Much obliged.
Time being item number 60 and 61.
You are aware, you feel an item. So, Mr. Halloy, they are waiting for this.
I'm sorry, Lordship. At 2, Lordship, they argued in court number 18. It continues. Just now I got
same matter.
Same matter.
Mane,
they are one of the petitioner. Another 2 petitioners also there, Lordship. Just now it was completed. Just. And also some other cases are also pending before court number 10, court number 21, court number 3. I'm helpless, Lordship. More than 25 bail matters are pending today. 9 loan detail also. Facing a very difficult situation.
Even if that be the position, then yes. That I just asked him that if there's any such kind of difficulty.
And this
maybe
matter, perhaps this matter has been heard by Justice M.R. Pathak, Lordship, earlier. CD has been
acha. Oh, yes, yes.
The order has been passed for placing a notification, Lordship.
One matter is also disposed by court number?
No.
No, my lord. These FIR, my lord. May I
Not
please
this-
your lord?
Not this FIR.
Has been heard by Justice M.R. Pathak.
May I please your lordship?
Yes, Mr. Bora. You're
Am I audible, my lord?
no, you are audible, but you're upside down. You're
Oh, sorry.
just we are trying.
Upside. I'm already upside down, because I'm in hospital, my lord.
Yes. Anyway, you are audible otherwise.
My lord. So these case was not been disposed of by any other court, my lord. This particular case, my lord. Though it was heard by the Justice M.R. Pathak on the other day, but as your lordship is taking up the special act, that is why probably this matter has come before your lordship today.
Okay.
Maybe that is the reason. My lord, in this case, my lord, the petitioner, he is Mr. Hemant Rava, my lord. He was arrested on 4/9/2024, my lord. Sorry, my lord, he was arrested on 5/9/2024, my lord. So his time started from 5/9/2024. Today I am 77 days in custody, my lord. My mandatory period for 60 days comes to the end on 3/11/24, my lord. And my bail application was pending from 4/10/2024. So bail application is pending, and in this case, my lord,
Bail application is pending since 4/10.
yes,
No. Just a second, in our the record, it's not showing that this.
Bail file, my lord, bail file.
Your bail
On bail
application
file,
number, please tell us, bail application number.
bail filed on 4/10/24, my lord. Bail application number 3152. 3152.
Item number 61. Oh, just a second, it will done. Your application is 3152, no?
Yes.
3152.
Yes, my lord. 3152.
Ah, yes. Okay.
So his mandatory period, 60 days, my lord, that comes to an end, my lord, on 3/11/24, my lord.
Yes.
Lord, please note down the dates, my lord. Very
I have already, yes.
So just one day prior to my 60 days mandatory period, the section 316, subsection 5 of BNS been added. Just one day prior to my mandatory period of 60 days, because to make it a 90 days detention period, maximum.
What are the sections added?
Basically, 316, subsection 5. So that is 90 days. So now I was in custody, my lord, from 5/9/2024 onwards, and the CBI has taken up the investigation subsequently, my lord. Initially, it was not before the CBI. Now, my first contention I have already raised before the other court also, and that is the jurisdiction of the CBI to take up this case, my lord, the investigation. So, Lordship, the Honorable Justice M.R. Pathak, I have placed that some material. My lord, in this case, what happened? The state government has given the consent to investigate the matter to the CBI. CBI otherwise can't enter into a state domain unless it was given by the state or by the constitutional court. That law point is settled. So here the state government under section 6 of the DSP Act, Delhi Police Establishment Act, given the consent to hand over those cases to CBI. No point, there is a notification to that effect. We are not disputing that notification. Then, as per the requirement of the DSP Act, because CBI has to now extend this jurisdiction from Delhi to the various part of the state government, so there has to be another notification that has to be under section 5. So it extends the jurisdiction. Otherwise, CBI can't enter into the jurisdiction of the other places or the state. An extension of the jurisdiction also required. So that extension is under section 5. So to that effect, there is a one notification also. Now the contention, my contention is very simple, my lord. We are not disputing these two. Now, Lordship, kindly take up.
Court number 7 is also some matter, other matter. Can I let London Senior Counsel argue? I'll join in, Lordship. Only for a few minutes, Lordship.
Your junior will be there?
They will be here, Lordship.
Yes, okay. Yes, Mr. Bhatt.
My lord.
Yes.
Then, Lordship, kindly take up the DSP Act, my lord, for a moment. Now, DSP Act, Malad, first logically take the section 5.
DSP, both things.
Delhi police.
Delhi Special Police Establishment. Yes.
Lordship, can you take up section 5? Very
Section
important.
5.
Yes. This section 5 says the extension of powers and jurisdiction of the special police establishment to other areas. The central government may, by order, extend to any area, including the railway areas, in a state not being the union territory, the powers and jurisdiction of the members of the Delhi policemen establishment for the investigation of any offences or classes of offences. Now this is, Lordship, kindly mark it, specified in a notification under section 3. So, it can hand over the investigation to Delhi police establishment under the DSP Act to CBI. There is no problem. That is under section 6. But the next requirement is that there has to be a notification under section 5. Otherwise, DSP Act only operates of Delhi and the union territories. So, for extension of the jurisdiction, there has to be another notification that is under section 5. So accordingly, there is a notification being issued under section 5 here also, extending the power. We are not disputing. But the last line, Lordship, mark it again, that notification has to be in consonance with the offences specified in Act can be operated by
Actually, we are having some problem in this. That's why.
May I continue, madam?
Your voice is, in fact, sometimes it is audible and sometimes it becomes, I mean, the voice is cracking also. That's why finding some sort of difficulty in. We have some problem.
Yes,
in
I can
fact,
understand.
yes. In the morning hours also, it was asked to things to look after these things, but again, it's remained same, I think. কি কৰিব এনেকে শুনিব নোৱাৰিব otherwise you are audible but sometimes your voice is in the cracking, it's cracking, your voice is cracked, that's why কি কৰিব
Madam, let us try for a few seconds.
Yes. We are just trying again for these things. Just for holding for 5 minutes. Am I audible,
problem.
Mr. Bora? Just
Yes, Lordship is absolutely audible.
Consulting with our operator, in fact.
Okay.
Just for 5 minutes.
No issue.
মানে sophisticated হোৱাৰ পিছতো problem আহি যায় not only the pictures মইতো শুনি আছিলো শুনাটো মাতিছিল নেকি খবৰ দিছে কাৰণে কৈছিলে এইটো প্ৰব্লেম হৈ আছে অলপমান ফিজিকেলি Are you okay now, Mr. Bora? How are you now? Presently?
Presently, my lord, I am hoping for discharge within 2-3 days. My lord.
Within 2-3 days?
Yes, confirmed.
Again, your
Within
voice
2-3
is
days, I may. Yes, I can see your lordship and hear your voice very well, but I don't know.
Your voice is sometimes it's clear only, and
I can.
Again, that is the happening.
Yes.
By the time, doctor, you can submit.
I also, my lord, adopt this submission, my lord. So far, my lord, 5, 6 is concerned section, my lord. 5 and 6, my lord. 3 has to be also complied, my lord. Section 3, if your lordship goes, my lord, for once, my lord, it has to be notified, my lord. My book I have given to your lordship, my lord. Section Section 3, my lord.
তেখেতৰ হেৰিটো আপসাইড ডাউন হৈ আছে আৰু ভইচটো আপোনাৰ ইয়া হৈ আছে অকমান সাইড অপশন পাই নেকি তেখেতৰ নেটৱৰ্ক Am I facing difficulty on my part or this computer is also same?
Otherwise, video, so far video is concerned, it's okay, my lord.
Video is okay.
Okay, but the voice, sometimes it breaks, my lord. Let him
Now he is saying that this is from that side only
problem. We'll log in once. Lordship, what we'll do, my lord? I'm logging in once again, my lord. Maybe next time.
Okay. Yes. You log in once again. Otherwise, what you are submitting that
my lord,
section 3.
Section 3, my lord.
My lord, with regard to their case, lordship, we'll be filing a written objection.
There is a different thing. Let me because I am behind the bars.
You can written objection.
Oh yes.
And in connection to 60, he is appearing on. Bora is appearing on 61. You have to deal with the 61 first. Okay. Only one.
I am the lordship. I am the manager of that 61. And I am behind the bar for 53 days. Now, Bora has gone to the roots of the case, whether CBI can investigate the case or not. Section 5, 6, and 3.
Have you taken your lunch? Hello.
No chance, lordship. No chance. No chance.
Busy for a whole day today.
For last, I think, 10 days, lordship. Same schedule, lordship. Hardly I got time to sleep also, lordship. Hardly I got, because at the same time, hearing matters are also been fixed. That is the
You are the only counsel.
Only counsel. One more counsel, but he is an ineffective, lordship. Now I am only the CBI counsel here in High Court.
That
I
is the
wrote to the
problem.
department also to engage, lordship. Process has already been initiated, lordship. But I don't know, very soon they are going to appoint it. But this stretch, lordship, after the entrustment of this 41 cases, lordship, very difficult, lordship. And in one court, 6 court, the cases were distributed. That is the difficulty.
But
at the same
I
time,
can
all the
understand.
cases.
That's why in the morning also I just told him that if it is not at all possible, take 2-3 days, more dates one. But they thought that he is behind the bar for a considerable period. That's why the matter was there.
With regard to the stand of the petitioner.
I think Bora has logged in well.
Yes, Mr. Bora, yes.
My lord, am I audible now, my lord?
Yes, you're audible now.
Obliged. So, my lord, there are two notifications is already there. But main foundation of the CBI to investigate, that is under section 3, that is not there. My lord, Lordship kindly take up the section 3 of the DSP, my lord. What are the requirement?
Yes.
Section 3 says this: the central government may, by notification in the official gazette, specify the offences or classes offences which are to be investigated by the Delhi police establishment. So, central government has to issue a notification in the official gazette, my lord, before taking up the investigation, my lord. So, CBI only can investigate the offences which has been published in the official gazette by the central government. That is the foundation of the source of power of the CBI. Otherwise, CBI can't investigate all offences. That is a clear proposition of law. CBI can't investigate all offences. It has to be notified. Then only they can investigate the scheduled offences. Now, in this case, whether the said notification under section 3 that the CBI can investigate the offences under the BNSS or any of the provisions of the BNSS which is connected in this case, either 316, 315 is there or not in the notification manner. So my contention is there is no such notification when this matter was investigated by the CBI, published in the official gazette. Now, just Council has placed one notification of 18 June in this regard, but the said notification is just an official communication admitted by the Council himself, and it is not a gazette notification published as mandated by the section 3 of the DSP Act. So section 5 also says that they can only extend the power of the CBI to investigate, provided they have a power under section 3, and the section 3 is very clear. Now I am placing one judgment of the Supreme Court in this regard, that is very special. 2020-20 SCC 531 paragraph 20 itself. How Supreme Court interpreted section 3, 5 and 6, my lord. One paragraph is sufficient enough to understand the whole proposition of law. Just one paragraph, small paragraph. Paragraph 20, Lordship, kindly take it.
Yes. Yes.
This court in M. Balakrishna Reddy expanded the purport of the section 3, 5, 6 of the 1946 Act and observed in paragraph 90 as under. The plain reading of the CBI in a state other than the Union Territory or the railway areas, consent of the state government is necessary. In order, other words, before the provisions of the Delhi Act exercise jurisdiction by the state,
Mr. Bora, you are again, your voice is again breaking in.
Checking my.
Yes, yes. Not audible.
Probably there. Because of software, probably it has been used, my lord. Just half an hour back, my lord, I have argued in another court.
আচ্ছা সময়টো টাইমটো দেৰি হৈছে যে।
Because we are using right now may not be very.
Yes, কি কৰিব?
Lordship,
Yes, doctor, yes.
in reply, Lordship, they only are disputing the fact that there is no notification, Lordship. I'm placing
No,
a
that's why I'll just hear you. But the question is that his part cannot be
completed.
Yes. Mr. Bora, what to do again? Facing some problem. In fact, you are not audible at all now.
Yes. Try to.
Yes, what to do? Say, they were not audible. In fact, you can talk to him, talk with him over telephone. Yes, just talk. Tomorrow, how many matters are there? 6.
Am I audible? No.
Are you going to be released today?
My lord.
No, you'll be
No,
discharged
my
from
lord, that's the
hospital
problem.
today. You will be discharged from hospital today
My
only.
lord. No, my lord.
No.
Maybe on Friday itself. No. My lord, matter on Friday. Friday.
Friday. You want to come on Friday?
Friday.
On Friday, you'll be able to
I'm
appear
delayed.
before the court physically.
Either way, my lord, if possible, I'll come down physically, my lord. And if I'm not discharged, my lord, I'll try to do it again by VC, my lord. If lordship permits me, my lord.
Or otherwise, we can fix it. Tomorrow will be possible for you. Tomorrow. We can fix it tomorrow. If first half the problem is not there with your network, then that
I have
might
no
be
problem.
tomorrow.
As a first
But
item.
Yes, tomorrow.
As a first item.
Yes, lordship. absolutely no problem, ma'am.
Otherwise, listening
Tomorrow-
you, just voice is cracking and we are finding difficulty. In fact, in the morning hours may not be, there may not be any
Yes,
problem
ma'am.
with the network issues, may not be. Kali first reading list for
Probably Zoom or Google may be more convenient for login, my lord, rather than the platform right now we are using, my lord.
Zoom is
The other courts are using Zoom.
Zoom allow for file. কৈছে জুম হলে বেয়া নহয় বুলি জুম এলাও কৰিব পৰা যায় নেকি সুধিব লাগিব if it can be allowed we'll just enquire the matter if it can be allowed in the Zoom also or either in the first half in the first hour the first or second item if it can be fixed as a first or second item that may be heard tomorrow but facing difficulty hearing you because your voice is breaking sometimes it is okay but sometimes it's breaking again
my lord.
Okay.
Can I tell you? Again in court number 7, matter is going on, and 3 is also pending. Court is looking for it.
Okay.
With regard to lordship, the other item, lordship, we need 3 days time to lordship file our written objection. That matter should not come tomorrow.
Should not come tomorrow. No?
This two are similar matter only. Related. My lord, these two are related matter, my lord. Arising out of the same affair.
Related is different thing. Yes, obviously, yeah, this is a related matter. That's why both the matters were together now.
Yes.
Now he is saying that in your matter, he was going to file the objection. We have to give a time to the petitioner side. That much.
I'm the manager of the.
No, no, whatever it is, I don't know. Maybe your
Yes.
manager. But tomorrow I may have some problem in approval tomorrow. It can be hard. Then my second half of
We'll let it be on Friday, Lordship. If your Lordship has some problem tomorrow, Lordship, Mr. Bora will also be trying to available on 22nd Friday. As per your Lordship's convenience, sir. Matter was already
60 million. Yes, ma'am.
let it be on 18, Lordship. Not 18. Look it here. Today is 20. Let it be on the 25th of November, Lordship. Monday, Lordship.
Yes, my lord. But
Monday.
So, yes, ma'am.
second attempt করলে দিয়ে দিব খালি দিয়ে দিলে বাকি এটা তুমি তিনটা বলে ঠিক হবে শেষ করে it will list tomorrow and it will listing it tomorrow
First, as a first or second item.
As a first or second item. You remain here for as a first or second item. We'll see. Or as a special category, we'll consider it because otherwise, in second of the network issues are there and we are not able to hear him properly. Mainly the issue on the regarding the notification issues
Yes,
are
yes.
there.
Already notification is there.
Okay, you place it.
I'll place it by tomorrow.
Okay, right.
I do.
God bless you.
Keep the put yes out. Let us test. It's over. $57. Let us fix কৰিছে মানে
Last occasion, he took time for taking instruction. That 10,000 rupees maintenance, I gave proposal for 8,000 because matter has been stayed out.
Oh, yes, yes.
Definitely.
Well, I have talked to my client, my lord. The income shown by the wife that I have a mineral water plant. There was a sick industry, my lord. Initially, while I filed the objection,
I'll hear this part.
Those things will come in evidence during
Yes,
trial
no,
because evidence has not started. Only on the
recently-
basis of assets and liabilities, this order
recently,
has
my
been
lord,
passed.
that plant has been closed down.
Those are
That
developments
plant
later
has
on.
closed down recently. So, my lord, his income
That is not before your lordship,
good.
that those documents.
So,
That
my
is a
lord,
closed.
he has said that, my lord, he can pay at least 6,000 rupees per month.
That is
my
too
lord.
late. Nowadays, lordship will understand. Because she met with an accident, she is having physiotherapy and all. That has been stated in my petition also, maintenance petition.
She's
That
an
is the problem.
architect and
That is different.
designer.
Her degree is there.
Whenever I
But
start,
she,
my lord, my
immediately
friend
after marriage,
starts objecting.
lordship will kindly see.
I don't know why.
Immediate objecting
Because,
is, I'm objecting on
because,
a quantum maintenance.
she is an architect and
That I'm
interior
admitting
designer.
she's
She
architect.
has her own income. And I
Lordship
am
will
a
kindly see.
jobless person. I had a mineral water plant
Lordship will
that
kindly
has been
see.
closed down.
Now, see,
She
it's
met with an
okay,
accident,
your
she is having
vinyl
physiotherapy.
vinyl plant at present may be closed down.
My lord.
Those,
She may be
let
an
him bring it
architect.
during evidence.
She may be an architect, everything will be there, come out in the evidence
Yes,
itself.
yes, my lord.
Whether she is earning
Yes,
or
my lord.
not, whether she
Now it is
is
the initial
despite
stage.
having such kind of
Considering that
qualification, why
aspect,
she
my
is
lord, considering
sitting. That matter that will come.
Yes, yes,
Now the question is that considering your assets and liability statement,
Yes,
the
my lord.
learned trial court below had passed the order of
Lordship.
interim maintenance 10,000.
10,000.
Now he is saying that
I am
he may
already
consider
reduced
it,
by this court.
8,000. If
That was not reduced, that was interim measure.
Otherwise, we'll hear and
It was reduced by this court up to 5,000.
That was not reduced, that was interim measure.
As interim measure.
As
It
interim,
was
that
reduced
was
by
not reduced.
10,000. So, I can pay 6,000 per month.
6,000 is
dispose of
too
this
less.
matter.
Nowadays, the lawsuit will.
I don't know if
So I have already brought down to 8,000 from 10. And there is no illegality in the order as such. That you also will kindly see. Had there been some illegality, then things would have been different. And they have to lay their evidence, I have to lay my evidence, those things are there.
Without considering my
The assets and liabilities has been considered also. Kindly
it was
see.
not properly appreciated.
I have also perused the statement of assets and liability affidavit both the parties. So both the parties assets and liabilities are concerned.
I have shown my income.
Whether that is believable. Whether that is believable. And here he has not stated that here plant is not working. Those things are not there. Now this is new development.
he has already filed his written statement.
Written fine.
Yes.
Yes, fine.
Where in the written statement
Those
also
things are not
not-
stated.
So we have not taken such plea in
Let him take this plea during
Now,
trial.
if having a water plant, a person having a water plant,
that has been
is
closed
it
down.
believable that he will
That has been
monthly
closed down.
income
That is a
will be
new
only
development. Bring it
4,000?
during
That has
evidence.
been
Just
closed.
see.
That has been closed down. That is why it was closed down.
Just
Because
closed
he
down,
could not
but
earn.
WSL is not there.
He could not earn anything from the plant. It has been closed down. That is the only
Because you
reason.
have married her, that is your
my lord,
duty.
Reasonable.
It
4,000 per month.
No,
That
not
impossible.
4,000, my lord. It was 5,000, and my friend has
No,
suggested.
your
You
income.
are earning presently 4,000.
Income you are showing
That is why, my
4,000.
lord, as it was not, my lord, giving any income, that is why it has been closed down. That is the only reason, my lord. Had the plant was working properly, my lord, it could not have been closed down. It has been
That
closed
let
down.
him lay this evidence before a trial court. Trial court will decide those things regarding. At present, let it be 8,000. I have already reduced to 2,000.
I have proposed for, my lord, he told
he will propose for me. He may
Lordship
propose
dispose of the
5,000.
matter, my lord, in between, my lord, in between 6,000 and 8,000. Lordship will dispose of the matter.
I have already told him
In between, my lord. He has agreed to 6,000. So Lordship will dispose of the matter in between, my lord. 7,000.
Not so.
Or Lordship may hear the matter on merit, my lord.
Because the thing is that trial court stay has been granted. That is also difficulty. The
Stay
trial has
granted,
not come.
but you're getting 5,000?
Right now he is
I am paying
getting
regularly, my
5,000.
lord. I am paying regularly, my lord. That amount
That I am not
paying
denying.
regularly.
That I am not denying. 5,000 I am getting. But the trial also is held up. And 1 year since order was passed in 2023. That was on 11/12/23. Almost 1 year. Also will dispose of. Otherwise, no use keeping pending out here.
Since 11th year.
11, almost 1 year.
In between, have you filed your, it has already been stayed.
Already been stayed, that's why.
Alternatively, my lord,
Why stayed?
Stay was granted, I don't know, I was not there. Because in the day one itself, stay
5,000
was
may be
granted.
there, but stay.
Whole trial has been paid.
As regards the stay, Lordship may modify the interim order, my lord. Let the If you lost, my friend is not agreeing
No,
on
no, if,
7,000.
this entire matter will go now.
Oh, no use keeping giving it pending out here.
Yes, I am asking you, even in spite of going with the entire merit of the case,
My lord.
if it can be disposed of.
Yes,
Now
but
he is
that is
saying
why,
that
I've
he
opened
is
the
considered
instruction,
to 8,000.
my lord. And my client
it
has
is
agreed to
agreeable, then
6,000.
we'll fix it
Client
on
was always
7,000.
agreed for less.
Lordship, the dispose of the matter on 7,000, my lord.
It is up to your lordship.
Let it be disposed on 7,000,
My lord.
better maybe so that it can be heard and decided at
Leave it to your lordship. I'll
Otherwise,
leave it,
this
because no use keeping
My
it
lord.
pending out here.
pending out there.
Let him be happy.
He is, what to say, he is also earning rupees 4,000 per month. So from where he will
So for
keep-
how will he manage?
My lord, his father,
He is
from
having
his
three
father's
properties. They are
pension, my
having.
lord, from his father's pension, my lord, is paying.
That he will only know.
Yes.
heard, this is item number 55.
Item was 57.
57.
Oh, sorry.
Supplementary.
IS here.
You are for the petitioner.
He is for the petition.
Heard Mr. I's second, the counsel for the petition, and also heard Mr. T. Kaluta, the learned counsel for the respondent. Bakin Lihibo. This is an application on section 397, slash 401, reduced section 482 CRPC, being for quashing of the impugned order dated 29/9/2023, passed in FC criminal case number 535 of 2021 by learned principal judge from the court number 2, Kamrup M1. It is submitted by Mr. Saikia that while the order impugned order dated 29/9/2023 because have you annexed the order? Order at page?
Order he is annexed.
Page?
My lord.
Order is at page?
Impugned order is at page 51, my lord.
51.
My lord.
So and so the learned principal judge family court Kamrup M has directed the present petitioner to pay interim maintenance at the rate of rupees 10,000 per month in disposal of the until further order slash disposal of the case. Aggrieved to the order passed by the learned principal judge so and so, the present petition has been filed seeking the modification of order not modification. Setting a certain portion of the order with so and so, as the petitioner is not in a position to pay rupees 10,000 per month towards interim maintenance upon today. Further, it is submitted by him that the presently the accused, the petitioner is not having any monthly income and he is depending on his parents and hence not in a position to pay the interim maintenance at the rate of rupees 10,000 per month as directed by the learned principal judge. Next, Mr. Kaluta submitted in this regard that the present petitioner has not taken those plea in while filing his while submitting his written statement as well as while while producing the assistant liability certificate before the learned principal judge so and so. The learned court below accordingly passed the order of interim maintenance only after appraisal of the assets and liabilities submitted by both the petitioner and the respondent. However, Mr. Kalkar submitted that the petitioner is ready, the respondent is ready to accept rupees 8,000 per month, uh, uh, per month towards the interim maintenance till the disposal of the petition maintenance, till disposal of the case, body learning principle just so and so, and further submitted that as the case is stayed by order dated 11/12/2023, case is not yet proceeded and the parties are not in a position to adduce evidence or to file the relevant documents, etc. before the court. Next, Mr. Saikia, the learned counsel for the petitioner, submitted that the petitioner is ready to pay rupees 6,000 per month, as he is not in a position to pay rupees 8,000 or rupees 10,000 per month as directed by the learned court below. After considering the submission made by the learned counsel for both sides, and without going on into the merits of the case, I'm opinion that rupees 7,000 may be justified and reasonable amount at present towards the interim maintenance till the disposal of the source. Both the counsels appearing on behalf of the petitioner also agreed to the quantum of interim maintenance at rupees 7,000 per month. Accordingly, with this observation, now one question is there. We are fixing 7,000, but as per 11/12, there was 5,000.
And that was found as an interim measure.
As an interim measure, 5,000 was there. So from today onwards, it will
Today onwards, it will be 7,000.
from the date of today. And the petitioner will accordingly pay rupees 7,000 per month from the date of order till
From next month, my lord. From December, my lord. From December.
It will be counted as 1 month.
From December. my
From
lord.
today to
Seven.
next month, it will be 1 month. From December.
Yes. From
This month he has already paid.
so monthly wise too. That's
Monthly
why
wise.
it will be
So
on the
next
month.
time it will be next month.
It will be dispose of it. Okay, then you pay 7,000 per month.
Stay order will be vacated. Stay order.
Stay order. So and so. The stands vacated. As on 11/12/2022 stands vacated.
Oblige, my lord. Oblige.
There are lots of other matters, but it's to be adjourned.
Hello,
item number 43. It's a very easy matter. It will not take any time. It's a matter that was settled in local law on 49. Minor modification of the order has to be. It can be taken up on priority lordship tomorrow, day after lordship. It'll just take 1 or 2 minutes, lordship.
Day after tomorrow.
Any day, lordship, but on top of the list, lordship. It'll just take, but that amount has to be
You're saying
modified.
item number?
Lordship? 43.
43.
It's a MSCG appeal that was disposed in a local law. The amount has to be corrected, lordship. It will be taken up on
Then we are listing it on Tuesday. Monday,
Tuesday.
there are lots of matters have been picked.
Tuesday, lordship.
Tuesday or
Monday.
Wednesday, as per your convenience. Either
Lordship.
Tuesday or Wednesday.
If it is on the top of the list, it will be harder.
Wednesday is not.
Tuesday, I will not be available.
We fix it on Wednesday then?
No, Lordship, next week I will not be available.
Get
Next week I will not be available.
No, just alteration or modification, which is he sought for.
Let it
Do
be
you have
Fri-
any objection there?
Let it be Friday on Friday.
Which Friday? Next Friday. This Friday, lots of matters are there. We will be able to. Next whole week you are not available.
No, I will
The
be
entire
out of
week.
station.
Let's just day after, lordship, after next week.
Then after next week only. Next week to KTL case. First week of December.
So Monday is the second.
Monday is 2nd of December. 2nd December.
Let it be.
2nd December then?
4th December.
My lord, item number 45. 45 may be taken, my lord, on Tuesday, my lord.
Item number?
Bail hearing, my lord.
Bail hearing?
Yes.
No, it's not a hearing, criminal appeal. What's a
Criminal-
suspension of sentence is there?
Yes. He is in jail for
Tuesday, I
last
cannot
more than
see.
5 months. Tuesday.
Let us see. It is a 24 matter. We cannot say Tuesday will be possible or not. It is beyond 5 to 6 to 2 or 2nd of December, 3rd of December. 5th also many cases. 3rd can be this month. We're fixing it on 6th December. Otherwise, cases list is full. In fact, 6th of December.
6th. I'll know. Can we 5th?
5th.
5th.
So list is full. In fact, 5th is also.
5th.
Okay, wait.
Similar prayer,
Alright.
my lord. Item number 40 and 42, suspension of sentence, my lord. Applicant behind bars since last year, my lord. More than a year. So, my lord, any day next week, my lord.
40,
40 and 42.
40 and 42.
Yes, any day next week, my lord.
Twenty-seven can be 27, 28. Already fixed matters.
I'll
are
take only
already-
10 minutes, my lord. Small issue, my lord.
No, small issue.
Only 10 minutes.
It will take 10 minutes.
Yes.
But first week of December only.
One item then, my lord. At least one item. At least item 40, my lord. Next week.
Okay, 43 maybe on 28.
42.
Oh, 40. You're
Two.
insisting 42
40
or
and 42.
No, one matter will
Yes,
be-
yes. 42.
42.
Yes.
Oh, this is more important for you
Yes,
for
yes,
24
yes.
matter.
Yes.
Okay, it will be on 28.
My lord.
Okay.
Highly appreciate.
Other one is 6th of December.
My lord. And item 51, my lord. Any date, my lord. I'm not, because it took a long time to get it listed, my lord. It's a hearing matter and IA is also pending, but it was decided that the matter would be heard together. But it has not been listed for a long time. Any date, my lord. Any date, my lord.
Oh, it's a hearing matter, no?
Hearing matter. So any date, my lord, because it took a long time to get it listed for hearing, my lord.
Any fixed date, take it over there. In the month of first week of December will
First week, second week doesn't matter, my lord. Any is just a date, my lord. Otherwise, it will not get listed, my lord.
11th of December. 11th is Wednesday, na? Then it will be 10th. 10th of December.
My lord, similar prayer my lord, with regard to item 39. My lord, first week of December, my lord.
51.
Worship, similar prayer.
Item 39, my lord. First week of December, my lord, any day.
So 24 matters actually, 23 matters.
Then 6th of December, my lord.
No, 6th, 5th already full. Make it on, it is a order column, na? Make it on.
Though
11th.
it is order, my lord, there is an urgency, my lord.
11th of December. What to do? We don't have any alternative. 11th
11th,
of December, 39. huh?
Well, item number
Obliged.
44, similar prayer. Any date may be given, Lordship.
পাৰিব কিবা ডেট দিব order column. 1-6.
My lord, item number 35, Lordship. Interim order is there, my lord.
What?
Item number 35, Lordship. 37, sorry, 37. Item 37, Lordship. Interim order is there, Lordship. I continue the interim order, Lordship. I am not
37.
seeking any date, Lordship. 37.
37. Criminal petition.
Yes, Lordship.
Interim was there.
Yes.
Into interim continue.
Obliged.
Okay, we're continuing. After 1 week, 2 weeks, we'll get over.